With the kind permission of the leadership. Leadership, there are two matters which we need to withdraw due to some technical errors.
Right.
If the matter can be listed in to be mentioned list tomorrow, kindly.
You're seeking liberty?
I'm seeking, I'll take liberty, Lordship,
Give the names.
Lordship, oblige. I'm good.
Correction of order dated 15/6/2023, by the Honorable Justice.
What is the correction necessary?
Lordship, on, it is a matter relating to the contributory provident fund to general provident fund. From the date of pension will be allowed from just after the date of retirement, but the order was on the date of retirement. That
Oh, a day earlier. Just give the number. To be mentioned, correction. Correction to be mentioned. Sorry to be
Lordship, once I virtually mentioned there, but file was not there.
File has to be sent in that case. Correction, contempt, these are to be taken up by court benches who deal with the matter. You're aware. So I'm sorry, I cannot help you.
It's difficult to.
I'll send it to the registrar. Where the file be sent, you can mention virtually. Because it is his order, correction has to be done by him. I would have loved to help you, but I'm sorry, I can't be helped.
So if I file a can with regard to this.
Same thing, it is his order after all. So his lordship has to do it. But he then immediately gonna file. Yes. Yes, sir, you've been waiting.
My lord, may I have leadership's kind leave to mention, my lord, motion, my lord. My lord, this is with regard to a pensionary benefits, my lord. The pensionary benefits has not been fixed. Petitioners have retired. My lord, pensionary benefits, my lord, the slab that ought to have been fixed, my lord, has not been fixed, my lord. My lord, one matter is that, and other two matters, my lord, motions, absolutely. My lord, with regard to, my lord, fixation of pay scale, they are not retired.
Have you put the other side on notice?
My lord, upon notice, I'm mentioning, my lord, three matters, my lord. Grateful, my lord.
Your lordship, may I be?
I would one motion state. I would mention, but
It was? Yes.
I have mentioned the case number wrong.
Very good.
Your
Yes.
lordship,
May I?
mention one matter, your lordship. On the last occasion, your lordship, it was running as item number 28, your lordship, and the display board was showing 15, your lordship. Eventually, when I came, your lordship, 29 was already taken up, your lordship. It has been next circuit. If this matter could be taken up any
Next
day,
circuit is not Mondays, madam. This time, it's a regular circuit now. It's next Monday.
Yes,
You can
Your
wait for these 4 days, isn't it?
if
Come
the
back
matter
on
could be
Monday. An
taken-
order has been passed, and this is no ground at all.
Lordship, and
Next
one
circuit
non-prosecution.
sounds very long, but no, it's on Monday.
Lordship, and another matter for non-prosecution, your lordship.
To be mentioned.
Lordship, may I kindly mention, one CAN application filed on 14 July, supposed to appear today's list.
Can for what?
Can for the during pendency of the writ petition and before the expiry of the filing of affidavit, they issued recovery notice, my lord. This is group 4 GST matter. For stay, my lord, I have filed CAN application.
Give the number. Give the number. Are you?
My
Have you put the other side on notice?
Yes, my lord. And also supposed to appear today's list in form B indicated the date today's list, my lord, but not appeared. My lord. Also, I have upon
Give the number.
sub the notice
Please
also.
give the number.
I'm grateful.
May I be allowed to mention one matter, my lord?
My lordship, matter and repetition are out of question of FIR নিয়ে আমি ফাইল করেছি। এটা হয়েছে ডিসেম্বর মাসে 2022।
168 একটা হিয়ারিং ম্যাটার আমার মনে হচ্ছে। Yes.
আমি
পুলিশ এসে আমার ঘরের সামনে একটা সিন ক্রিয়েট করে উইদাউট এনি রিজন, আমাদেরকে কোনো কিছু জানায় না কেন এসেছে, আর মাকে সেদিন ওয়ারেন্ট করার চেষ্টা করেছে। মা বলেছে কি কারণে ওরা চলে গেছে। মাই লর্ডশিপ আজকে আমি যখন আজ জলপাইগুড়ি এসে পাহাড়পুরে বাস থেকে নামলাম, তখন আমার বাবাকে ওনারা নিয়ে গেছে। আমার মা আমার সাথে এসেছিল, আমার মা, বাবা, আমি, পিটিশনার, সেই পিটিশনটা। মাই লর্ডশিপ আমাদের উপরে দীর্ঘদিন যাবত এই পুলিশ অত্যাচার করছে। মাই লর্ডশিপ আমাদের প্রাইভেট স্কুলের থেকে বড়
কি
সত্যি
আপনার বাবাকে থানায় নিয়ে গেছে? এটা criminal determination এর bench has to, isn't it? The criminal bench has to, determination bench has to deal with this.
Yes, ma'am. I don't know Milord, on what grounds he has
in
been
writ,
taken into
yes.
custody, Milord.
যিনি criminal matters take up করছেন ওনার কাছে গিয়ে বলুন এটা। এইভাবে তো বোঝা যাবে না। আমি বুঝতে পারছি আপনার অসুবিধাটা কোথায় হচ্ছে, অসুবিধাটা কোথায় হচ্ছে। যে বেঞ্চ, যে অনারেবল জাস্টিস ক্রিমিনাল ম্যাটার্স ডিল করছেন ওনার কাছে গিয়ে এটা মেনশন করুন, উনি যা করার করবেন, যা করণীয় উনি করবেন। রিট ম্যাটার ইজ নট কানেক্টেড, আমরা জানি না রিট ম্যাটারের জন্য কি অন্য কোনো কারণে, উই ডু নট নো দ্যাট, দ্যাট ইজ, ওটা একটা আলাদা কিন্তু কজ অফ অ্যাকশন। হ্যাঁ, পুলিশ ডেকে নিয়ে যাওয়া, ধরে নিয়ে যাওয়া ইজ এ ডিফারেন্ট কজ অফ অ্যাকশন অল টুগেদার। হ্যাঁ, আমি একটা টেকনিক্যাল টার্ম ইউজ করছি, আমি সরি, আমি বোঝাতে পারছি না হয়তো। হ্যাঁ, এটা একটা আলাদা ইনসিডেন্ট, ঠিক আছে? এটা যে এই রিট ম্যাটার গুলোর সাথে কানেক্টেড কিনা আমরা এই মুহূর্তে বুঝতে পারছি না, ঠিক আছে? আপনি ওই বেঞ্চে মুভ করুন, ওই উনি যদি মনে করেন উনি রিপোর্ট কল ফর করবেন, বা উনি যেভাবে মনে করেন উনি সেইভাবে করবেন। হু ইজ ডিলিং উইথ দ্য থার্ড বেঞ্চ ইজ ডিলিং উইথ দিস, ইজন্ট ইট? হ্যাঁ,
My lordship, আমি যে ওখানে কোনো ফাইলিং করি কোনো পিটিশন এমনি নেবে জাস্টিস। আমি যে
Mr. Ghosh, how do we help her?
No, Milord, not in this.
How
case.
can we help
Milord,
her?
there were personal
This is
allegations
not-
leveled against me by this individual, Milord. I refrain myself from, Milord, interfering into it.
আপনারা থানায় গেছেন কি যখন আপনার বাবাকে নিয়ে গেছে? আপনারা জেনেছেন? আপনারা থানায় গিয়ে জানুন কেন ওনাকে নিয়ে যাওয়া হয়েছে ওখানে। আর আমার যেটা মনে হচ্ছে আপনার ম্যাটার গুলো একটু কমপ্লিকেটেড, তো আপনি নিজে নিজে ডিল করছেন, সেটা না করে আপনি যদি লিগাল এড চান এখান থেকে, লিগাল সার্ভিসেস অথরিটি আপনাকে একজন উকিল বাবু দেবেন, সরকারি খরচায় তিনি আপনার হয়ে মামলাগুলো করবেন। আপনি তো আইন পড়েননি, আপনি তো স্টুডেন্ট অফ ল নন, সুতরাং আপনি যে অনেকগুলো মামলার কথা বলছেন, তো এটা একটা পুলিশের কেস ঢুকে গেল, এছাড়া রিট পিটিশন পেন্ডিং আছে, কিছু মোশন স্টেজে, কিছু হিয়ারিং স্টেজে। আপনার কি মনে হচ্ছে আপনি একা একা হ্যান্ডেল করতে পারবেন এই মামলাগুলো? যদি আপনি কনফিডেন্ট না হন, কারণ এগুলো কিন্তু প্রত্যেকটা খুব সিরিয়াস মামলা। হ্যাঁ, শুধু আপনার যদি মনে হয় আপনার একজন লিগাল সাপোর্ট দরকার, আপনি, আমার মনে হয় প্রথমে আপনি থানায় গিয়ে জানুন কেন ওনাকে নিয়ে যাওয়া হয়েছে, তারপরে আপনি নেসেসারি স্টেপস নিন।
আজকে যে ম্যাটারটা আছে সেটা কিন্তু আমাদের স্টে অর্ডার নেই। মাই লর্ডশিপ ওই ম্যাটারটা যদি উঠিয়ে দিতেন তখন ওটার জন্য হতে পারে না।
এইভাবে তো দেখুন, হতে পারে না পারে, এইভাবে তো কোর্টে মামলা করা যায় না, মামলা হয় না। আমি এই কারণগুলোর জন্যই আপনাকে বলছি, আপনি যদি কোনো একজন উকিল বাবুর সাহায্য নিতেন তাহলে আমার মনে হয় আপনার মামলাগুলো ঠিকঠাক ভাবে করা যেত। কারণ আপনি এক একদিন এসে এক একটা গ্রাউন্ড বলছেন, এক একটা জিনিস বলছেন, এইভাবে কিন্তু মামলা হয় না। আমি জানি না এটাতে আপনার কতটা উপকার হবে, আমি বুঝতে পারছি না। আপনি একটু ভেবে দেখুন এটা।
আজকে এই ম্যাটারটা কি মাই লর্ডশিপ আপনি নিতে পারবেন যে কোনো সময়?
আপনি যে ইনসিডেন্ট বলছেন তার সাথে এই ম্যাটারের কোনো কানেকশন নেই, আমি তো প্রাইম অফিসে বুঝতে পারছি না কোনো কানেকশন।
মাই লর্ডশিপ
এইভাবে তো হেল্প করা যায় না, আপনাকেও তো প্রপার প্রসিজিয়ারে আসতে হবে, তাই না? আপনি জানুন গিয়ে কেন আপনার বাবাকে নিয়ে যাওয়া হয়েছে, তারপরে আপনাকে একটা কমপ্লেন করতে হবে বা আপনাকে নেসেসারি স্টেপ নিতে হবে। এইটার জন্য কিন্তু আপনার লিগাল অ্যাডভাইস দরকার। আপনি কিন্তু জানেন না আপনাকে কি করতে হবে, আপনি জানেন কি?
মাই লর্ডশিপ কিন্তু পুলিশ বাবাকে আজকে নিয়ে গেছে, কিন্তু পুলিশ মেইন টার্গেট তো আমি। মাই লর্ডশিপ
এগুলো তো সব আপনি বলছেন, এগুলো তো একটা লিখিত আকারে কোর্টের কাছে আসতে হবে এগুলো।
মাই লর্ডশিপ আজকের এই ম্যাটারটা আপনি দেখে
আজকের ম্যাটারটা যখন আছে আমাকে, আমি কল করব, আমি তো জাম্প করতে পারবো না, একের পর আমি 196 নিতে পারবো না, আমাকে 1 2 3 4 করেই এগোতে হবে, দ্যাট ইজ দ্য প্রসিজিওর। আপনার মতো অনেকে আছেন যাদের খুব আর্জেন্ট ম্যাটার্স আছে, আমি সবসময় নিয়ে উঠতে পারছি না, ইজন্ট ইট? আমি তো ডিসক্রিমিনেট করতে পারবো না এইভাবে। আপনি আগে জানুন কেন আপনার বাবাকে নিয়ে যাওয়া হয়েছে, তারপরে নেসেসারি স্টেপস নিন। দরকার হলে কোনো উকিল বাবুর সাহায্য নিন, আমি আরেকবার বলছি। দিজ আর সিরিয়াস ইস্যুস, যেটা আপনার পক্ষে হ্যান্ডেল করা কতটা সম্ভব হবে আপনি ভেবে দেখুন, ঠিক আছে? আমি কিছু করতে পারলে আমার খুব ভালো লাগবে, আমি বুঝতে পারছি আপনার মনের অবস্থা, আপনার কি হচ্ছে, কিন্তু আমি তো এইভাবে কিছু করতে পারছি না। হ্যাঁ, আগে জানুন কেন নিয়ে যাওয়া হয়েছে, ওনার বিরুদ্ধে অভিযোগটা কি। পুলিশ তো নিয়ে গিয়ে আটকে এমনি এমনি রাখতে পারে না, কোনো একটা অভিযোগ আছে ওনার বিরুদ্ধে।
মাই লর্ডশিপ যখন শুক্রবার দিন ওনারা এসেছেন তখন উনি তো অনেক চেষ্টা করেছে, অনেককে পাঠিয়েছে। মাই লর্ডশিপ ব্যাপারটা হয়েছে বারের আলিপুরদুয়ার কোর্টে বার আমার এগেইনস্টে দাঁড়িয়েছে, সেটা পিছনে একটা রহস্য আছে, সেটা সমস্ত আমার বাবার সাথেই জড়িত।
এগুলো সবটা কোর্টে একটা অ্যাপ্লিকেশন, একটা কেসের মাধ্যমে আসতে হবে, প্রপার প্রসিজিওরে আসতে হবে।
অবশ্যই
আপনি একা একা যেটা হ্যান্ডেল করার চেষ্টা করছেন, আমার মনে হচ্ছে এটা আপনার ইয়ের বাইরে চলে যাচ্ছে, আপনার কন্ট্রোলের বাইরে চলে যাচ্ছে। এইভাবে কিন্তু মামলা করা যায় না। হয় আপনাকে প্রত্যেকটা মামলা পুঙ্খানুপুঙ্খ ভাবে পড়াশোনা করে দেখে শুনে আসতে হবে, না হলে কোনো লিগাল এক্সপার্টের হেল্প নিতে হবে। এইভাবে কোর্টে এসে মুভ করে আপনি কিন্তু কোনো সুরাহা হবে না আপনার। আপনার হয়তো শুনতে ভালো লাগবে না আমার কথাগুলো, কিন্তু আমি খুব প্র্যাকটিক্যালি বলছি কথাগুলো। হ্যাঁ, কারণ আইনের ফোর কর্নার্স এর মধ্যে থেকে আপনাকে যা করার করতে হবে। আপনি জানুন কেন আপনার বাবাকে নিয়ে যাওয়া হয়েছে, পুলিশ ডেফিনেটলি একটা নিজে থেকে কমপ্লেন করবে, বা কারোর অভিযোগের ভিত্তিতে নিয়ে যাওয়া হয়েছে আপনার বাবাকে, সেটার বিরুদ্ধে আপনি যা করার আইনত স্টেপস নিন।
আমি লয়ার আমি এখান থেকে লয়ার নিবো, কিন্তু আমি লয়ার নিয়েও নি, তার পিছনেও সেই কারণে লয়ার আমার সাথে কিছু হ্যারাসমেন্ট হয়েছে মাই লর্ডশিপ, যার জন্য।
আপনি বলতে চান এন্টায়ার জলপাইগুড়ি বার আপনাকে হ্যারাস করেছে?
তাও একটা লয়ারের জন্য, কারণ সে আমাকে সাজেস্ট করেছে তুমি নিজে যাও। আমি
আমি তো একতরফা শুনে কোনো কথা বলবো না।
অবশ্যই মাই লর্ডশিপ
আপনি রেজিস্ট্রার, who is the secretary of the legal services authority here, the registrar? Who deals, are you aware?
No, my lord.
আপনি রেজিস্ট্রার সাহেবের সাথে কথা বলুন, উনি বসেন, ওনার সাথে কথা বলে আপনি যদি লয়ার চান আপনি কথা বলুন, ঠিক আছে? Yes, next matter.
My lord, item 53, my lord, today's list, my lord, I was led by Mr. Kishore Datta. My lord, Friday this was taken up. My lord, without my lord hearing us, my lord has passed an order fixing the matter in the next circuit. Wrongfully, my lord, probably, my lord, inadvertently, it has appeared today.
Oh,
My lord, I am only praying, my lord, if my lord takes it up, my lord, any time today, my lord, subject to
it has been
convenience of.
ordered to be placed on in the next
Yes, my
circuit.
lord, but without
is
hearing
appearing
us.
wrongly.
My lord, I was not present, my lord, on Friday, I was in
Maybe
the principal.
you are for the petition or the
Yes, my lord.
maybe no one appeared on call.
No, my lord, appeared, my lord, someone appeared, my lord, accommodation was sought.
আজকে কত আছে? এটা wrongly, this has been wrongly filed, wrongly
Yes,
recorded. Today
Admittedly,
it is
my lord,
actually
wrongly filed despite my lord's
161767,
order.
not 1707.
Despite
It's a
my
wrong
lord's order.
printing.
My lord, I am
So
only
I
praying, my lord, this can be taken up, my lord.
No,
for
it cannot,
hearing.
cannot. Come back next Monday.
Grateful, my lord.
This matter is in year 2020 December, motion was rapid. Respondent were directed
Please.
by.
শুনুন না।
Directed by affidavit of consent. Till then, 2 years, 9 months elapsed.
Affidavits have not been filed.
So, after affidavits are complete, matter cannot be.
Right, yes. Are you mentioning upon notice?
Yes, my lord, I have notice and I have also direct the order here.
Give the number, please.
May.
এটা hearing এ appear করুক, hearing এ appear করুক।
Attention, my lord.
Not to,
Online order is required.
দেখি affidavit হয়নি বলছে ভাই।
I have.
To be mentioned,
I have
এখন
order
affidavit
sheet
file
also,
হয়নি।
my lord. Order sheet also. Sir, notice upon the order, sir.
To be mentioned.
My lords, may I be permitted to mention, my lords?
0 এটা 6 এই ফাইলটা এলো কোথায়? ও এটা ফ্রেশ ফাইল। ও আর ওনাদেরটা 1707। ও নট টুডে করে দিন, কালকে দিন।
My lords, may I be permitted to mention, my lords?
Yes,
Today's
yes.
item number 187, my lords.
Yes,
My lords, I had indicated the urgency earlier, my lords. There's a direction by the Chief Justice, my lords. The urgency is that my goods have been detained, my lords. And my second-hand goods, they have treated it like a first-hand goods, my
it's a
lords.
hearing matter
Yes,
and it's
ma'am.
appearing in the list.
Yes, my lords. Kindly upgrade.
You have just heard what I have said, the other person. I cannot upgrade, I'm sorry. 85, 90 matters are being filed per day. So how do you expect me to upgrade? Last day's filing was 85, I believe, Mr. Shah. So how? I have to sit in 2 sessions in that case. One in the morning and one in the evening. Not possible. I'm sorry, I would like to help, but then it's very difficult. Yes, call the days list. please.
Lord, I beg to appear on behalf of the petitioner, my lord. My lord, matter was mentioned for incorporating the names of my seniors, my lord.
Correction.
Yes, my lord.
Yes, your name has not been
My
mentioned.
lord, my name is there, the senior's name is not there. In this matter, my lord, Parthopratim Roy and Mr. Dutiman Banerjee was appearing virtually, my lord.
For the
Lord,
petitioner.
For the petitioner.
Right.
for the statement.
You are there. Your name is
Yes, madam.
correction of the.
Yes, madam. I was there in the initial audit.
The matter has come up under the heading to be mentioned at the instance of the petitioner. Paragraph inadvertent error has crept into the order passed on 2nd August 2023. Paragraph in the cause title of the order. The names of Mr. Parthopratim Roy, Dutiman Banerjee, be recorded as learned counsels for the petitioner in addition to the name of Mr. Devanjan Das.
My lord, and Dutiman Banerjee.
Yes, Dutiman Banerjee and Parthopratim Roy. Give the names for abundant precaution. Paragraph. The department is directed to incorporate necessary correction accordingly. This order be treated as part of the order passed on 2nd August 2023, urgency certified website copy.
Deeply obliged, my lord.
Was there any e-mentioning? I have forgotten to ask, e-mentioning আছে কিছু? E-mentioning আছে কিছু? কেউ তো বললো না কিছু। লবিতে নেই কেউ? লবিতে নেই? Yes. Item 2. Petitioner,
Yes, ma'am. My lordship,
Yes.
not today, madam.
not today means next circuit. No further adjournments can be granted.
Okay, my lord.
What is this application about? I believe it's a restoration
Yes.
application.
Yes, my lord.
So this application also you cannot move.
Not today, madam.
You are appearing in this matter, isn't it? Make your submission.
Actually, conducting advocate is sick.
You are appearing in this matter. You are the advocate on record.
Just conducting advocate asked me.
Who are you in this matter? Who are you in this matter?
I'm just submitting.
You are not connected to the matter at all.
I'm connected with it.
How are you connected? You are you are appearing for the petitioners in this matter?
Yes, lord.
Yes.
Yes, lord.
So why can't you submit on a restoration application also? Make your submission. You're practicing for how many years?
This is my first appearance before
Before any
High
court?
High Court.
When have you joined?
I have joined in 2014.
This is 2023.
Yes, my lord.
Make your submission. This is a restoration application.
My lordship, I
Otherwise-
don't have brief with me, so.
I'll direct this matter to appear next year. 2024.
No,
Only
my
because of
lordship,
you.
kindly fix it in next circuit.
What is this, sir? 2014 to 2023, you're in court. You cannot move a restoration application.
Actually, my lordship, I
You
don't have,
think you
I
are
don't have,
an advocate at all?
I don't have brief with me.
Don't you think this is very unfortunate?
I apologize, my.
Very unfortunate state of affairs, sir.
Kindly
You
fix the
spend the
matter.
rest of your life with passovers and adjournments. You've not even learned to move on a restoration application in all these years, 9 years of practice.
Actually, my lordship, I don't have brief with me, so.
You will not have a brief also in future.
Kindly fix
On
the
prayer of
matter.
the petitioner, let
Next
the
circuit.
matter appear before the next available circuit bench. Very unfortunate, very unfortunate.
Grateful.
May I please your lordship, I am for the petitioner lordship.
I'm for the state lordship.
This is regarding, my lord, termination of non-teaching staff of Loreto Convent lordship, who was in the school for the 20 years lordship.
Miss Ananda, she is appearing for this school.
Yes.
Now, thing is that lordship, she has been hospitalized. She has to undergo a surgery
Oh.
today. And bring for next circuit.
In the and lordship, one thing with regard to the maintainability of writ petition, he is claiming a writ petition against a private school. This school is absolutely a private school. It has got nothing to do
How
with.
is your petition maintainable?
It has got
Lordship,
nothing to.
there are several judgments, Lordship, and recent judgment of this our Honorable High Court also, Lordship, regarding this 226, Lordship.
That in,
against
even a
the
private
audit.
dispute is maintainable?
Yes,
Writ
Lordship,
petition?
Lordship.
I'll keep
As
the
per
issue
my,
of-
This is
as
not
per
dis-
my instruction, lordship, this is a absolutely private school and this is not lying.
It is not maintainable.
It is not maintainable.
No,
lordship.
no, Lord. Let them agitate all this matter in their affidavit, Lordship. This
Not
is
necessary, sir.
maintainable, Lordship. This is maintainable. I will satisfy before your
Please
Lordship.
show me how it is maintainable.
Lordship. This is the Sarab,
Because admittedly, you have filed the application against a private.
Lordship,
response,
Lordship.
isn't it?
And they have formed this one kind of illegal, this committee, Lordship, and member of, yeah,
They are all private responses.
yes.
Nothing
Well,
to do
let
with
them
the-
file affidavit, Lordship.
Not necessary, sir.
No,
Please satisfy the court on the maintainability.
yeah,
first.
we can, Lordship.
Yes, the relevant paragraph.
Entire order is on maintainability, Lordship. 23 onwards, analysis by the court, Lordship, jurisdiction of the High Court under 226, Lordship.
This is an army public school.
But
this
this
is a
is
government
also
school.
private issue, unaided school, Lordship.
Army
It
public school is a
is,
central government.
it is
affiliated school.
affiliated to CBSE, Lordship, and my school is affiliated with ICC. There is
Okay,
violation
but
of
an army
statute.
school is a government school. It's not. a
No,
private
it is
school.
private school similar to my school, Lordship. But in this school, Lordship, the Lawrence school also, Lordship. Madhya Pradesh. This is after. Where is that?
Where is the relevant paragraph?
From 26 on, this
24.
24 onwards.
কতদিন না কপি?
2021 SCC online.
আরে
CAM
কপি-
one.
কপি-
Will give.
Citation আছে তো, তুমি নিয়ে নাও।
Please provide the citation to the respondents.
Lordship. Okay, we'll give the sites.
Will you consider this and come back?
Lordship,
Yes.
Lordship, in this case, kindly put the next circuit because she will.
Very well. I'll keep the issue of maintainability open.
Let them file the exchange of affidavit, Lordship. No, there are a lot of judgment, Lordship. There are several.
Place them before the
11
next
bench
circuit.
judgment also.
Please place them before the next circuit.
Lordship.
You can take this back now because I'm not hearing the matter.
Lordship.
You're on behalf of
School, respondent number.
respondent number 5
No, Prince 5.
or the
I
secretary
got the
managing
respondent
committee
number 3, lordship.
3.
Yes.
Learned counsel for the 4th and 5th, I think, isn't it? 4th and 5th at the school. Fourth and 5th respondents. Seek accommodation. Paragraph, let the matter appear before the next available circuit bench. Paragraph on prayer of the respondents, comma, the issue of maintainability is kept open.
Lordship.
You can take the judgment back, you can give it
Let's-
to the next.
My lord, I'm appearing for the petition, Lordship.
Yes,
Lord, my affidavit of silence.
respondents,
Lord, the state and central, alternate respondent is the state, my lord, state is represented. Lordship, the matter.
give you a minute, please. Who is there for the state in this matter?
My lord, I am appearing.
You're appealing?
Yes. My lord, the
For
matter.
All the respondents? These are all state,
Both the respondents are here. Both the respondents are.
Union of India, you're.
CGST and Union of India. I am for CGST department.
My lord,
Yes.
what has happened here, Lordship? uh, an adjudication was done. Against that adjudication, I have come directly by way of writ. A question may arise why I have not availed the alternative remedy. That is because the adjudication has been done completely without jurisdiction. Why I say this? My lord, the dispute that has been agitated and alleged in the instant adjudication order, my lord, the dispute is not triable under GST laws at all, because the liability, if any, have to be tried under the VAT laws. Because Lordship knows better than me, my lord, that on and from July 1st, 2017, GST Acts came into being, replacing the Value Added Tax Act. Now, Lordship will kindly come to this. This is your petitioner, my lord, is a cancer patient who had worked for the Public Works Department in various stages. Now, page 18 is, my lord, the contract that had been awarded to him by the Darjeeling Gorkha Hill Council. Page 18, annexure P1.
Yes.
My lord, second paragraph. This is to notify you that Executive Engineer, Special Department, Engineering Division, DGHC, has been authorized to accept your bid by the Chief Engineer such and such for execution of work, construction of road from Pubong Phatok to Rombi, length 15 kilometers under RIDF 15 for a contract price of such and such. My lord, why I say this bold portion, which is underlined as well, this is very important. So this, my lord, is the letter of acceptance. Lordship kindly turns the page 19.
This is in 2010.
2010, exactly. Then page 19. This is the completion certificate awarded to me for such work. This is to certify that Sri Tashi Bhutia, the petitioner, my lord, contractor P.O. Dolopchand Kalimpong, was awarded with the work viz. Construction of road from Pubong Phatak to Rambi, length 15 kilometer under RIDF 15, amounting to this rupees, only wide work order number such and such. And he was awarded to complete work from 0 to 7 kilometers, amounting to 6 crore 80 only, which he has completed on 21/6/2012. So my provision of service, if any, was completed on 21/6/2012. Now, in the light of this, Lordship will kindly take section 13 of the CGST Act. My lord will forgive me for marking the book. It was already marked, I see, while handing it over.
Oh, that's all.
Section 13.
Yes.
Time of supply of service, the first subsection. The liability to pay tax on services shall arise at the time of supply as determined in accordance with the provisions of this section. So the liability will arise at the time of supply. Now, what is the time of supply? That is subsection 2. The time of supply of service shall be the earliest of the following dates. There are 3 dates, 3 incidents given. So the taxable incident happens to be the earliest of them. The date of issue of invoice by the supplier, or the date of provision of service if the invoice is not issued within the prescribed period, or the date of receipt of payment, whichever is earlier, or the date on which the recipient shows the receipt of the services in his books of accounts, in case where the provisions of clause A or B do not apply. Now, Lordship will once again come back to the petition. Here, so I am stating that I am under clause B, since my provision of service was completed on 21/6/2012.
Yes.
Even if the other clauses are there, whichever is earliest, so this is the earliest date that can be, nothing can date back to that. Even if it dates back, then it's also VAT Act. If it dates ante, then only it can have a provision and can have a supposition that it might be
Under the CGST.
Under the CGST Act. So when the provision of service is completed on 21/6/2012, it is guided by completely the VAT Act and not by the GST regime. Thereafter, my lord, page 20 and 30 happens to be the medical reports of the petitioner, my lord. He's a cancer patient, suffering severely. Page 22, Lordship will kindly come. This is once again very important. Lordship will see this is a statement which is received from the Executive Engineer, Central Planning, Quality Control and Procurement, such and such place, by Sri Tashi Bhuti. It is sort of a ledger. It's sort of a ledger account maintained by the DGHC, that is the Darjeeling Hill Council. My lord, 2 dates are noted against 2 voucher numbers. Their own bill, Lordship knows how the bills are passed in the government. They, after my bill, they issue their own bills. And then, Lordship kindly see name of the work. Construction of RA from Pubong, Photok to Rombi under RIDA 15. So the same project. Payment is being made, gross value, whatever the gross value, total of the gross value, my lords, is 1,74,88,287. My lord, this part was a part payment which was payable to me, which was not paid at that time. Lordship knows government payment, it comes with a delay. Now this payment has been released on which date? This payment has been released, left hand side second column, my lord. One is on 27/8/2019, the other is on 18/3/2020.
This is after the CGST Act came.
After the CGST Act came to play. Now what has happened? Already, since I do not have anything to disclose in the under the GST, whether it be WBGST or CGST, I have not declared anything. But now they have made the payment. So TDS has been done. In my form 26As, it shows that I have made a payment. I have been made a payment. And now, my lord, from that, the West Bengal GST authorities, they have come to the conclusion that I must have provided services. Although that is not the case. And now, why I say this, that 1,74,88,287, this figure is very important. Lordship kindly comes to page 25. That is the show cause notice, gist of the show cause notice. According to record,
Yes.
according to records of TDS credit received by the RTP available to this office, the RTP has supplied taxable goods and services to Finance Department, Darjeeling Gorkha Hill Council in 1920 worth rupees 1,74,88,287. So, my lord, Lordship kindly sees the misunderstanding gets cropped up from here. This amount tallies squarely with that amount, which happens to be a payment or a part payment from my previously done job. Then, but the RTP has not disclosed any turnover in your return submitted in GSTR 1, GSTR 3. Now, my lord, they had given me show cause. I should not say that opportunity of hearing was not extended to me. It was extended. But due to this precarious condition of your petitioner, my lord, he is a cancer patient suffering who is at a very advanced stage of the disease. So he could not go and could not represent himself before the authorities, neither could he contact the advocate. So this show cause notice went unanswered. This is my candid submission, my lord. I cannot improve upon the facts that is there. Then Lordship kindly comes to page 29, which is the adjudication order. 74, order under section 74. 29 is, my lord, the cyclostyle. Lordship kindly comes to page 30. Here again, tax has been calculated on that same amount, 1,74,88,287. Page 30.
Yes.
On the same, the tax has been calculated and a tax, interest, penalty, everything has been compiled and a hefty demand has now cropped up. So, my lord, that is the be all and end all of the case. My lord, I have already tallied the figures, how I have received the payment and what is it all about. My lord, the thing would have been completely clear had there been a hearing, and it is, my lord, being a victim of the circumstances, the petitioner could not go. I am not saying that respondents have not given me the opportunity. They had given. They had issued the show cause notice. They had issued a gist of show cause. They have issued a summary. They have done their bit.
But you did not appear before
Could
the
not, my lord, he could not. He is a, that's why, my lord, page 20 and 19, 20 and 21, Lordship kindly comes. He is at a very precarious condition with a very advanced stage in the disease. He is undergoing chemotherapy and radiotherapy consistently. Page 20, Lordship sees, this is 10/4/2023, the latest, one of the latest reports. follow-up for carcinoma of the right vocal cord.
25 is the show cause
Show
notice.
cause
When was
notice.
this issued?
My lord, this was issued
20. No,
in 2020,
no, 2021, 23rd.
2021. My lord, 23/6/2021 to be precise. That is, the date can be obtained from page 23. And
And your medical documents are for 2023.
no, my lord, it is the most recent. Lordship turns the page, page 21. At the end, Lordship sees to meet us again on 5/11/2021. RT, that is radiotherapy, starting date is 12/7/2021. So on 12/7/2021, the gentleman was undergoing radiotherapy, which shows he was already in a quite advanced stage of the disease. 10/7/2021, the show cause notice was issued to me on 23/6/2021, barely a month, barely a few days before that.
Let us hear the response.
Lordship, kindly see page 23. It is 23/6/2021, the show cause notice. And my lord, at page 21, once again, RT starting date is given, fourth line from the top. RT starting
12th
date
July.
12/7/2021. It's 12 plus 7, that amounts to 19 days. On the 19th day, his RT had started, and Lordship can well imagine.
Very well.
The
Let us
condition.
hear. the
Miles.
response. Yes.
I only pray for one thing, my lord, that let this order be set aside, sent back to the authority. We will make our appearances and the matter will be cleared. That is it.
This is not a curious case. Milord, despite Milord, admittedly, he had undertaken a contract and has also done the job.
Please switch on the microphone.
And Milord has also done the job and has subsequently raised the bills also. Now, Milord, surprisingly, what has appeared that from financial year starting from 2012-13 till 17-18, when the VAT Act was in place, they have not filed any returns under the VAT Act. Now, Milord, that raises a question of suspicion. Subsequently, Milord, what transpired that the TDS which the department has deducted, that has been deducted under the GST laws. Milord, subsequent to 1st of July 2017, when the GST Act came into place. Thirdly, Milord, kindly turns over to the writ petition, Milord, at page, Milord, 22.
Yes.
Milord would find that, Milord, the date of the bills, the bills which were raised, that is subsequent to rolling out of the GST regime.
Yes.
Now, Milord, so far as our records are concerned, his proceedings, which has been initiated, has only been pursued with regard to 2 RA bills, which has been raised subsequent, Milord, to the rolling out of the GST regime. Since they have themselves not filed any return under the VAT Act, now you cannot take advantage of your own wrong. Now, Milord, kindly turns over, Milord, it is in my written instructions, Milord, the government has clarified this situation by way of a notification dated 16th August 2017. That is, Milord, probably, I don't know, Milord, whether it is annexed.
No, it's not.
Probably
I
it
do
is not.
find it.
Milord, I will just hand up a copy. Milord, the notification squarely, Milord, addresses the question. Milord, it says, with regard to work contracts where the supply is of both goods and services, works contract executed on or after 1st July 2017 and invoice bill raised on or after 1st July 2017, the mode of treatment will be under the GST Act and not under the VAT Act. This entire confusion has now been clarified. I'll just, Milord, hand up, Milord. I'll just fold the relevant page, Milord.
But here work contract has to be executed after 2017.
Yes.
But
Now,
here
Milord,
the work contract was
work, it's
prior
a
to that.
continuing, it's a continuing work.
No.
It's a
No, no,
continuing
no.
work.
Completion
It has
was
been
in
completed.
2012.
It has been
It's not a continuing work.
Now, Milord, the RA bills, Milord, I have shown, Milord, the bills have been raised subsequent to 2017. So
Yes,
once a
but
bill
the-
or invoice has been
Please show me
raised,
the circular.
yes, Milord.
The work was completed in 2012.
I have a little difficulty since I only have one copy, Milord. I could not hand up to my learned friend.
Milord, the RA bills are raised by the department upon the sanction being given to my payments. RA bills are not my bills. I make my bill, the department raises their own bill wide array numbers.
It's 25, no? Downward, separation of 25.
The first situation is applicable. Goods supplied before 1st July 2017. Invoice raised before 1st July, payment made after 1st July 2017. That is the case here.
No, Millard, I am not aware, Millard, as to the date when invoice was submitted. Millard, from the records, from their records, Millard, it appears.
No, no,
Millard,
it
page
is an
22.
array bill. It is an array bill.
I understand.
It is not
sir,
my
array
bill. It is
I-
not my bill.
I understand it's RA bill is also raised by the contractor. What are you saying, sir?
No, no, array bill is not
Running
my
account,
bill.
running account bills are also raised by the contractor. Its department does not raise any bill, please, sir.
Of course, in order to clear the payments, the department has to
no.
raise bills.
Millard, I have never heard of this. Department raises bill on behalf of a contractor. This is
Not on behalf of the contractor, but to the pay and accounts in order to get the payment disbursed.
This
That is the
your bill.
process.
This is your bill.
No, that's not my bill. Any payment which is disbursed
Millard-
from the government
Millard,
has to be
kindly-
billed to pay an
Services
account.
supplied on or after 1st July and invoice raised on or after 1st July.
Yes,
So in that case, you are saying that
the
CGST
treatment will be under the GST laws.
but services was supplied before 1st July 2017 admittedly.
Yes.
Well, Millard,
Completion
we are
of
not
work-
admitting to it, Millard. I have to seek further instructions.
Documents say so.
Millard, kindly takes
The
page
document says
25
so.
also once. Yes, but what Millard was pointing out to something, Millard.
The documents say so.
Yes.
Work was completed in 2012. So how does the 2017 Act come into play? Only page 25 is after 2017.
Millard, Millard, allow me to come back tomorrow, Millard, with instructions on this. Millard, I am not sure, Millard.
May I humbly
whether-
suggest one thing? I don't think my learned friend will stand in the way.
The reconsideration without going to
Yes.
merits.
On the
Yes.
point of this.
Only on this. Let them produce the
And here
documents.
is, I believe, a cogent ground. The show cause notice was admittedly not replied to. The person is a terminally ill patient.
Correct, that's right.
So why don't you give him this sympathetic approach
Grateful. Grateful.
without going into merits? I'll record that I'm not going into.
Yes,
merits.
yes,
Let
yes.
the person appear before you, let him give his explanation
Yes.
Yes,
Yes.
that is all I want, Lord. That is my innocuous
without
prayer.
spending further time on
My-
this.
my-
Let the authority decide. Because
My-
ultimately the authority has to decide.
Yes, definitely.
Grateful, Lord.
Affidavit of service. Paragraph. It is contended on behalf of the petitioner that the petitioner is carrying on proprietorship business under the name and style of Messrs. Tashi Bhutia, and was granted contract for construction of road from Poobong, P-O-O-B-O-N-G, P-O-O-B-O-N-G, Poobong Photo, F-A-K-A-T, F-A-T-A-K, Photo, to Rombi, R-A-M-B-I, comma, length 15 kilometers, under RIDF XV, Roman 15. Upon acceptance of his bid, bid letter issued on 29th July 2010, stop. Upon completion of the work, comma, completion certificate was issued. Upon completion of the work, comma, completion certificate was issued in his favor on
Certificate dated 2012,
23rd.
2012.
This is
Cert-
20 or 23rd?
20, 20, madam.
2012.
2012. I'll just check in the repetition.
Yes. On 20th December 2012.
I have written December 2012 since there was ambiguity in the date, but reflecting that the works was completed on
Yes,
21.
on the ওটা in December 2012. Was issued on in December 2012, indicating that the work was completed on 21st June 2012. Stop. Statement of payment was issued in favor of the petitioner by the executive engineer, Central Planning, Quality Control and Procurement, Darjeeling on
27th March 2023 from the stamp.
June is the stamp. This is 27, on 27th
27th
March
March
2023,
2023.
with regard to vouchers dated 27th August 2019 and 18th March 2020 respectively. Stop. Show cause notice was issued to the petitioner on 23rd June 2021 alleging that the petitioner suppressed the turnover of supply worth rupees 174,88287, 174,88287 in 2019-20, resulting in evasion of tax, worth rupees 3,147,890. Stop.
Lord, it
Since-
will be 3,147,890 plus the other figures as well. So the total comes to be 74 something.
Is it along with 18%?
Because the interest is also there, penalty is also there, and
along
two
with-
taxes.
So add column along with interest and penalty,
The
the
final
total-
figure is reflected at page number 30. That's the order.
the
75,5740.
Yes,
0.80. That's the total.
amounting to a total of rupees 75, 50, 746.80. 0.80. Stop. The petitioner being a patient of carcinoma, was unable to reply to the show cause notice due to his health condition. Stop. The petitioner was directed to make payment of the entire amount by 19th November 2021 before the authority. Stop. Paragraph, it is submitted on behalf of the petitioner that the contract of the petitioner is governed by the Value Added Tax Act and not the CGST Act.
GST, my lord, CGST or WBGST.
CGST/WBGST Act. Since the petitioner was unable to submit a reply to the show cause issued by the authority, comma, he seeks an opportunity to place his case before the authority before any penalty is slapped on him. Paragraph. Learned counsel for the respondents submits that learned counsel for the respondents refers to a circular issued by a notification issued by the Finance Department, Audit Branch, Government of West Bengal on 16th August 2017 and submits that the contract of the petitioner is governed by the CGST/WBGST Act and not the VAT Act. Paragraph. Upon consideration of the submission made on behalf of the parties, this court is inclined to hold that since the petitioner had no opportunity to appear before the authority to substantiate his case or file a reply to the show cause issued by the authority due to his precarious medical condition, justice demands that the petitioner be given an opportunity of hearing by the authority before any penalty is slapped upon him.
Liability,
Paragraph.
any liability is slapped upon.
Before any liability is slapped upon him. Paragraph, in view of the above, the final
Impugned order
impugned order
dated
is at page
29, my lord, dated August 24, 2021. Last annexure P8.
in view of the above, the order impugned passed on 24th August 2021 is set aside. Paragraph. The concerned authority being the respondent number,
1, lord.
being the first respondent hearing, is directed to revisit the issue upon affording reasonable opportunity of hearing to the petitioner and pass a reasoned order thereto within 1 month. Mr. Ghosh, 1 month?
Yes,
My lord, a bit more time may be allowed. Might be just 1 month, 15 days. Just having
6 weeks.
6 weeks,
Fine.
within 6 weeks from the date of communication of this order, in accordance with law. Paragraph, the petitioner is at liberty to submit all relevant documents before the authority in support of his case at the time of hearing. Paragraph, it is made clear that this court has not gone into the merits of the case and the concerned authority shall be at liberty to deal with the case independently and without being influenced by any observation which may have been made in this order.
And my lord,
This
since
was
no affidavit is called
Yes,
for,
yes, that will be
because
recorded.
that notification
Those are
part
the
I
usual
am.
lines that we recorded. Yes.
Great, great.
Random, or you check usually. You can take that.
Yes.
My lord, CGST also appeared.
Grateful to my lord.
Grateful.
You want to dispose of which appeal? Next,
My lord, 5, 6, 7, 8, I am for the petition, my lord. All
Yes.
matter relating to my lord interest of gratuity.
yes. Please place one by one.
Yeah,
Single PPO.
my lord, single PPO, my lord, died in harness.
Shorjo, single PPO died in harness. Who is appearing for the state? You are appearing
For the state.
affidavit of service, sir. Yes,
Six, my lord, single PPO, my lord, died, my lord.
died in harness.
Yeah, no, my lord, only died, single PPO. Only area pension, my lord. Interest of only area pension.
Petitioner has expired.
Yes, my lord.
Harness, sir. Who is appearing for the state? In this matter, you are appearing. Who is appearing? 6. Who is appearing for the state in item number 6? You are appearing?
Interest of gratuity and area pension, ROPA 2019, revised,
Revised PP.
ROPA 2019.
Shorjo, revised PP. State? You are appearing? Revised PP.
My lord, revised PPO, my lord, ROPA 2009. 2009.
State? Who is appearing? Revised PPO 2009 Roba. Next.
My lord, I'm appearing for the petition also.
Yes.
My lord, my affidavit of service.
Who is appearing? Respondents?
My lord, respondents are CGST and SGST.
Where are the respondents?
Affidavit of service. Although this matter, my lord,
I do not find the respondents. Anyone for the respondents?
CGST is here and SGST.
Yes. Mr. Ghosh usually appears.
Mr. Ghosh is here.
Where is Mr. Ghosh?
My lord, he has already been informed. He has already been informed. Go. दौड़े जाओ. My lord, what has happened in this matter is
Let
this.
him come.
Lordship. Smoke.
You've come up against the appellate order.
My lord. Here
Where
what
is
has
Mr.
happened.
Ghosh? Oh, he's there.
My lord, here what has happened.
Mr.
I
Ghosh, you
have-
ready?
I have been completely duped by my own chartered accountant. Lordship, petitioner is a 53-year-old lady residing at Darjeeling proper, having her business in Darjeeling. What has happened, my lord, just in a two-liner. Once the with the advent of the GST regime, things became way more difficult for aged people, because since it was all in computers and everything was in a different new changed format. So she had been thus predicated, my lord, she went before to a particular chartered accountant, and she had asked him to get herself registered and also to look after her IT income tax files, GST files, everything. She used to pay him regularly. Now this gentleman, what he did, he had made the communication address, that is the registered address of the business, to be his chamber address. The communication email ID to be his own email ID. And even the phone number with which the portal password can be manipulated or rather changed to be his own number.
That is generally done. By the
Generally done, it is given to the petitioner, or any common number is given, the OTP is generated, they ask the petitioner, give me the OTP. That is how, and sometimes it is also, but the address that has been given for the petitioner, and Lordship, I'm bearing the brunt of it. I am now, even in the cause title, I had to write that address because that's my registered address now. And I'm in the process of making it correction amendment in the registration certificate, but I have not yet done it. So I'm paying the brunt of it. I stay in Darjeeling, but Lordship will see my course title reads
Siliguri, yes.
Defense Colony, Bagdogra, Shiliguri. This is the address of the CA. How I did come to know of this? One fine morning, this your petitioner goes to the bank to withdraw some money. She comes to know that the bank account is attached. On further verifications and cross verifications, she comes to know that there has been a huge demand by the department. Rightly, wrongly, a demand by the department. This was told by the bank manager, and she got to see the attachment notice. She then contracted the Matigada office at Shiliguri, and there the office has helped her because all her portal documents have been given from the office to her. From their end, it has been given. Otherwise, she had no other way to get it, receive it. So now this person concerned, after getting all these receipts, she had filed a written complaint, not a GD, my lord. It's a written complaint before the police. Lordship kindly straightway comes to the written complaint, which is at page 57.
Yes.
My lord. Paragraph 4 will be very important. That in order to get, she provides catering service, my lord. And she also provides catering service to the police department only. Darjeeling Police and Shiliguri Police. These are the two clients that she provides. Darjeeling Police Commissionerate, I went to their office there. One person named Sandeep Kumar Jha introduced himself as a chartered accountant and assured me that he shall look after my accounting, income tax, GST registration shall be done by him in a few days against his professional fees. Next paragraph, next page, my lord. That being a layman, I entrusted CA Sandeep Kumar Jha with GST registration and accounting and signed in various forms and documents as per his instruction and obtained GST registration from appropriate authority within few days as assured. In the process, he gained my full trust and I appointed him as my consultant of income tax, GST accounting, including filing of periodical returns, paying due taxes. I used to hand over cash and transfer funds to bank whenever and whatever amount he told in lieu of payment of tax and other official expenses. That in the month of September 22, I went to Union Bank of India, my lord, as I had already narrated. Thereafter, Lordship kindly comes down to paragraph number 7. That on hearing the said information from banking authority, I directly went to the Bagdogra to meet CA Sandeep Kumar Jha in his office situated at Defense Colony, Bagdogra, District Darjeeling. The office of CA Sandeep Kumar Jha was closed for the next 7 days or more. I regularly visited his office premises, but it remained closed. I had also called him several times on his given mobile number, but he did not respond to my calls, and mostly the mobile phone remained switched off. Subsequently, I inquired from local people and his neighbors and found that the several people had asked about him in recent past, and also that he had cheated many of his clients and misappropriated funds and is absconding now thereafter. This is very important. That since I'm an old lady and does not have knowledge of the computers and online affairs, CA Sandeep Kumar Jha had my income tax password, GST portal password, email password, and I did not have any access to any of them. He often used to call and ask money for paying taxes, and I paid him in good faith, sometimes in cash, sometimes from bank account into his account. Next para. That subsequent to having knowledge of CA Sandeep Kumar Jha of misappropriation of client's fund, I appointed another professional to check my affairs of business. It is seen that the amounts paid to CA Sandeep Kumar Jha with regard to payment of income tax and GST hasn't not been remitted to the government exchequer. To mention, rupees 5,41,224 paid through bank account on 3 occasions. The dates are given. And then again, rupees 2 lakh on such and such day, and rupees 1,40,000 on such and such day. And again on such and such day, 25,000, 50,000 by cash has been misappropriated by him. Thereafter, 10th para. From the middle, Lordship, I am reading. It is worthwhile to mention, Lordship has got
Yes.
grateful. It is worthwhile to mention here in that from the GST department itself, I came to know the email submitted with the department was sandeepjha such and such @gmail.com. And address of principal place of business of Annapurna Caterer was Defense Colony, Bagdogra District, Darjeeling. That is his chamber. Be it mentioned that even the contact number updated with the GST department was that of the said CA Sandeep Kumar Jha, and as such, I had no inkling to the whereabouts of my GST and other liabilities. Thereafter, para 11, last part, my lord. Thereafter, I found out the address of the GST department, which is at Matigara, met concerned office authority. From there, I came to know that there is a demand for the year 1819 against my firm, Annapurna Caterers, which arose due to a work shown against my firm by Superintendent of Police Darjeeling, but during whatever. So now, my lord, here is the status, and then lordship will kindly come to. Now this order was passed by the department. It has already been passed. It has been attached. I had no other way but to go before the appeal. I went before the appellate authority, but a delay was already done. Page 73 is the condonation petition. 74 will be the effective para. Page 73, lordship kindly comes. This is the condonation petition. Para 3, 4, 5, 7, and 8 are important. Page 74, lordship. I'm placing from para 3.
You've
Your
given the
applicant.
explanation, yes.
My applicant information from a bank manager was made aware that bank account had been attached in pursuance to such and such proceeding initiated against her under section 74. Then para 4. Your applicant immediately tried to contact the CA appointed for taking care of her tax affairs. But to her utter shock and surprise, the CA was untraceable, and the petitioner, after due diligence from her end, found that the CA she entrusted with all her tax affairs was a fraud and had misappropriated with the funds of the applicant, owing to which the applicant lodged a written complaint dated such and such. Pursuant to the order, the recovery proceedings were initiated against the applicant, and notice dated March 16, 2022 for providing bank account details was also sent to the applicant. Yet again, the applicant was not informed by her CA about such recovery proceedings. Finally, upon the attachment of the bank account by virtue of the recovery proceedings initiated in Form GST DRC 13, the banker informed the applicant. Now, lordship kindly comes to para 7. Your applicant most emphatically submits that it is crucial to consider the extenuating circumstances outlined in her previous communications, such as unavailability of GST and income tax portal details, the absence of communication from her CA, and her limited knowledge of the GST regime. Therefore, an opportunity must be given to the applicant to produce the relevant documents at the time of hearing of the appeal, so that there cannot be any miscarriage of laws and rights given under the statutory mandate. Your applicant submits that the applicant could have filed the appeal within the time envisaged in the statute, but for reasons beyond the control as mentioned above, the applicant was deprived of the same, and the consequent delay was there. Now, my lord, after this, a show cause notice was issued to me by the department that why it should not be rejected. Page 79, lordship kindly comes directly. And my lord, page 77, there are certain case laws, 76 and 77, which if required, my lord, I will dwell. 79, lordship kindly comes. This is the show cause notice.
Yes.
Last but 3 paragraphs. Whereas it appears upon examination of the appeal application submitted in should be memorandum in Form GST Appeal 01 dated this, that the appeal has been filed beyond the prescribed period of 3 months from the date of order or decision appealed against, whereas it appears the time the appeal petition filed by you is liable to be rejected. So therefore, you are directed to appear on such and such at 3 p.m. before the undersigned, and to show cause as to why the appeal petition filed by you shall not be rejected on the above noted grounds. Thereafter, again, a reply was filed running from page 80 to 84. I'm not getting into it, lordship, because this is again repetition of the same.
So your appeal was rejected only on the limitation ground?
Only on the limitation ground. Only one small thing that I would like to point out before your lordship is that my lord kindly takes this order, my lord. This is a very, perhaps it's a very important and আমি একটু পরে দিই, আমার কাছে 3টে কপি আছে তো দিয়ে দেবো। Lordship kindly takes para 3. It will be very because this was already dealt by the Supreme Court.
Yes.
Para 3. The disturbing feature of the case is that under our present adversary legal system, where the parties generally appear through their advocates, the obligation of the parties is to select his advocate, brief him, pay the fees demanded by him, and then trust the learned advocate to do the rest of the things. The party may be a villager or may belong to a rural area and may have no knowledge of the court's procedure. After engaging a lawyer, the party may remain supremely confident that the lawyer will look after his interest. At the time of the hearing of the appeal, the personal appearance of the party is not only not required, but hardly useful. Therefore, the party, having done everything in his power to effectively participate in the proceedings, can rest assured that he is neither to go to the High Court to inquire as to what is happening in the High Court with regard to his appeal, nor is he to act as a watchdog of the advocate, that the letter appears in the matter when it is listed. my lord, the last line from the 5th in that same paragraph. What is the fault of the party who, having done everything in his power and expected of him, would suffer because of the default of his advocate? If we reject this appeal, as Mr. A. Sangvi invited us to do, the only one who would suffer would not be the lawyer who did not appear, but the party whose interest he represented. The problem that agitates us is whether it is proper that the party should suffer for the inaction, deliberate omission, or misdemeanor of his agent. The answer obviously is in the negative. Maybe that the learned advocate absented himself deliberately or intentionally. We have no material for ascertaining that aspect of the matter. We say nothing more on the aspect of the matter. However, we cannot be a party to an innocent party suffering injustice merely because his chosen advocate defaulted. Therefore, we allow this appeal, set aside the order of the High Court, both dismissing the appeal and refusing to recall that order. We direct the appeal be restored in its original number in the High Court and be disposed of according to law. So, my lord, this was already taken care of by the Honorable Supreme Court, and it's a celebrated judgment, Lordship. I'm sure Lordship already knows this, but I was tempted to quote this because the logic enunciated herein is the same. And now, my lord, will kindly come to the impugned order, page 85, 86. I will not trouble your Lordship with much. 85, I'm just highlighting the effective paragraph. Second paragraph, it is found upon scrutiny that impugned order was communicated by the AO on 17/1/22. Appellant has filed appeal petition on this after a lapse of 493 days. Then comes the Honorable Supreme Court's judgment, my lord, which excludes the time limitation. Then comes 107(1), that's the provision. And then that appellant was required to file appeal within 3 months, 90 days from the date of communication of the decision or order appealed against as stipulated under section 1071 of the WBGST Act, read with the corresponding section of CGST. Then 1074, which gives that 30 days grace, my lord. Lordship will kindly turn the page and come to the second paragraph. A show cause notice was sent to Joyashree Bharadwaj, appellant, on such and such, to its registered email address. Now it has been changed, my lord, as provided in GST portal and communicated by DIN number this, dated this, asking to appear on such and such and to show cause as to why the appeal application filed by him shall not be rejected on the aforementioned ground. The appellant, through her authorized advocate, appears and submits a reply pursuant to the show cause notice, stating that therein that the delay in filing appeal was due to lack of communication from the chartered accountant. Despite the appellant's diligent efforts to stay informed about her affairs, the appellant has submitted application for condonation of delay in filing while filing the appeal application, stating therein that the same reason as noted above. The same is perused by this appellate authority, but not found acceptable for the aforementioned reason. Therefore, my lord, it suffers its natural death. And according to us, the delay is of 359 days. According to them, it's 420 something days, 451 days. According to us.
Now, what has been shown to your Lordship, I have only one objection to it. A person having business receipts in excess of rupees 50 lakhs was expected to be more vigilant, because she was aware that the receipts are coming. It's not a believable scenario that I am not aware of my own business income. Milord, admittedly, as per record, Milord, in excess of
That is not his case at all.
Yes, I understand.
That is not her case.
Milord,
That's
now-
the
She
merit.
says that she has continued to make payments, but
Yes.
they were not deposited.
Yes, now, whether it is deposited or not, it depends on the returns that is being filed. If I file a return, I'm entitled to a copy of the return. So my only respectful submission is the petitioner was expected to be more vigilant. Shifting the entire blame after a delay of 1 year, shifting the entire blame on the charter accountant and evading payment of tax.
That is why I want the appeal.
Not proper to.
That is why I
Why
want to
don't
appear in the
you
appeal.
deal with her with the case on merits?
I can do that because there's no difficulty, but had the case been in case of a illiterate person, someone, an agriculturist who is not aware of anything, the case would have been different. And someone is a clear case where someone was not vigilant. You engage a chartered accountant and you don't know what are your returns. That is probably not.
The
appreciate-
turnover,
cannot be appreciated.
whatever my learned friend is submitting is on the merits, my lord. That is my merit of the appeal, and I will show
On
that there was
merits,
no
you will be at
turnover.
Liberty to decide.
Yes,
This was done only on the limitation ground.
my lord,
So let the appellate order be set aside
Right.
and let the appeal be decided on merits.
lordship, lordship, great,
Because these points that have been taken by the petitioner can be taken up, can be decided by the appellate authority.
my lord.
Yes?
And my lord, the citation was AIR 1981, Supreme Court 1400.
Right. It's here. Affidavit of service. The petitioner, who is the proprietor of a business in the name and style of Messrs. Annapurna Caterer, entrusted a chartered accountant named Sandeep Kumar Jha with the accounts comma, income tax, comma, GST, comma, GST registration and GST registration, comma, etc. with regard to her business. And continued to hand over cash and payments in connection with tax and other official expenses through bank transfer in favor of the accountant. Stop. In the month of September 2022, comma, the petitioner went to the Union Bank of India, comma, Shibok Road branch and was informed that her current account with the said bank was blocked. Stop. Was blocked. Stop now for it. Against recovery of her liability towards payment of GST.
If I may take Millard's, if Millard, okay.
The petitioner found that the registered address given to the authority, the registered address and phone number.
Registered address, phone number and email.
The registered address, comma, phone number and email ID given to the authority was that of the chartered accountant and not the petitioner. Stop. Several attempts made by the petitioner to contact the accountant thereafter were in vain, VAIN. And the petitioner learned that the chartered accountant had cheated many of his clients, including the petitioner, and was absconding. Stop. Upon meeting the concerned authority at the GST department, the petitioner came to know that there was a demand for the year 2018-2019 against her firm, which was not deposited by the chartered accountant. Where is the order against which the appeal was preferred? The recovery order?
The adjudication order will be followed at 53 to 54, Lordship. 51 to 52 is the memo, the cyclostyle part, and 53 to 54 is the order.
The petitioner was, by an
51 to
order,
52 is the order, my lord. 51 to 52 is the order.
yeah, this is the summary.
Yes, 51 to 52 is the order.
By an
52 to
order
50 is summary.
passed on 17 January 2022, the petitioner was directed to make payment of
7 lakh 46.
tax along with interest and penalty thereon to the tune of rupees 7,46,386.14 by 17 February 2022. Stop. The petitioner was unfortunately not aware of the said order. Upon having knowledge of the same, the petitioner preferred an appeal accompanied by an application under section 5 of the Limitation Act 1963 for condonation of delay in preferring the appeal. Stop. By a notice issued on 7th June 2023, the Joint Commissioner, State Tax within bracket appeal, Siliguri Circle, Siliguri, directed the petitioner to appear before the authority on 13th June 2023 to show cause as to why the appeal shall not be rejected on the ground of delay in filing the same. Stop. The petitioner submitted a reply to the show cause on 26 June
26 June
26 June
2023.
2023, following which the appeal was dismissed solely on the ground of limitation by an order passed on
27th June 2023.
27 June 2023. Stop. The said order is assailed in the writ petition. Paragraph. Learned counsel for the petitioner submits that in view of what has been stated above, the petitioner may be granted an opportunity of hearing before the appellate authority and the appeal be considered on merits. That is your prayer. Paragraph. Learned counsel for the respondents submits that the petitioner who is the proprietor of a business should have been more diligent in dealing with the financial aspects of the business. And it is not believable that the petitioner relied upon the chartered accountant entirely without caring to keep a vigil, VIGIL, on the activities of the accountant. Stop. Paragraph. Be that as it may, comma. না, এর আগে যেখানে petitioner সাবমিশনটা হলো ওখানে একটা লাইন লিখুন petitioner সাবমিশন placing paragraph করে placing reliance on an authority in Rafiq 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 and another versus Munshilal and another reported in AIR 1981 Supreme Court 1400. Learned counsel submits that the petitioner should not be made to suffer due to laches on the part of her chartered accountant. Paragraph upon consideration. No. In the authority referred to by learned counsel for the petitioner, comma, the Honorable Supreme Court has observed in no uncertain terms that a person who selects his advocate, comma, briefs him, comma, pays the fees demanded by him, and then trusts him to do the rest of the things. Cannot be blamed for not acting as a watchdog, of the advocate. Stop. It shall be useful to set out the relevant portion of the judgment. Stop it. Paragraph 3 to set out. Law of paragraph 3, something law. Paragraph. In the case in hand, comma, the petitioner contends that she has suffered due to faith and trust reposed upon the chartered accountant by her, and the chartered accountant taking undue advantage of the same. Stop. In view of the observation made by the Honorable Apex Court in the authority referred to above, comma, this court is inclined to hold that the petitioner is entitled to a hearing by the authority on merits before her appeal is disposed of. Stop. The order impugned dismissing the appeal on the ground of limitation is therefore set aside. The order impugned dated 27th June 2023. 27 June 2023 is therefore set aside. Paragraph. The concerned authority being the respondent number,
Two, my lord,
Assistant Commissioner,
my lord.
being the second respondent here in comma, is directed to reconsider the appeal.
My lord, the second respondent happens to be Assistant Commissioner, third respondent, lordship.
Joint Commissioner.
Joint.
Third respondent
Third
is directed to consider the appeal preferred by the petitioner on merits upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, and pass a reasoned order within 1 month. Within 1 month from the date of communication of this order, comma, in accordance with law.
My lord, CGST department has also been represented.
Give your name.
Yes, yes.
My lord, the limitation point stands resolved.
Yes, I said on merits.
On merits,
Yes.
on merits.
I've set aside this order
Lodge.
and I've stated on
Lodge.
merits.
Lodge.
Yes.
And my lord,
This
the
goes up with
usual
chapter
paragraphs.
Yeah, absolutely.
Grateful.
Grateful.
Next.
I beg to appear for the petition.
My lord, in
This is affidavit of service, madam.
item number 10
Yes.
and item number 11, both are so far I've gone through the matter, both are analogous matter, 10 and 11. I have 1 day accommodation. Kindly grant me 1 day accommodation. Tomorrow I will argue. I have to take further instruction from the department. I am appearing on behalf of CGST department.
Who is appearing for the WDGST?
No, my lord, this is service tax matter, my lord, under Finance Act 1994 and subsequent amendment.
Yes.
Service tax matter, my lord. I am challenging, my lord, here the show cause notice and also the adjudication order. Show cause notice is barred by limitation, adjudication order is without jurisdiction, my lord. An order passed beyond the scope of show cause notice, my lord. Those 1 point of original allegation not there in the show cause notice, but brought in the order, my lord. And thereafter, my lord, our reply contains that our work is exempted under Service Tax Act because works with the Railways Authority, Indian Railways
Please
Authority.
come back day after tomorrow. Let him come back with instructions.
Tomorrow.
Learned Council wants to come back with
Yes.
instructions.
my
Come back
lord,
day
learned-
after tomorrow.
Tomorrow.
Grateful, grateful.
Day after, day after.
Day after I have returned, my lord, to Kolkata. That is tomorrow, my lord. Learned Council says 1 day's accommodation, my lord.
There are several matters. I don't know whether I can reach.
My lord,
it.
my lord.
Not today.
Not to.
Really not today. 10, 11 both.
ঠিক আছে, কালকে। Not today. Not today.
Grateful.
I am grateful.
10 and 11 both are.
12.
Item 12, I am for the petitioner matter.
এগুলো urgent motion দিয়ে চলে যাবে। 10, 11, urgent motion এ চলে যাবে।
ওটা করবি?
My lord, I am praying for Passover because
Passover is not possible in this court, sir. I'm sorry.
not today. My lord, then
Yes.
petitioner work as a group D.
Take the microphone, please.
petitioner worked as a Group D employee at Sisuniketan Junior Basic School, Jalpaiguri.
Yes,
Thereafter, he retired on 31st December 2021. But
yes.
till date, my lord, he has not been given any pensionary benefit and retirement benefit. And representation was made. My lord, affidavit in service has been done.
Representation was made.
Yes, yes, my lord.
Yes.
Representation is in kindly see page number 64. In which representation has been given, but no reply has been given on my representation. They are completely denied my pensionary benefit, which I am legally entitled to. I have serviced full diligently. Now I am facing very hardship in maintaining my livelihood after retirement.
When did you retire?
I retired in December 2021. Now more than 14 months have been passed. Hello.
Yes, respondents.
This may be sent for consideration. Because he initially joined as a night guard.
You're appearing for all the respondents?
No. Your state respondent, DPSC is represented by separate counsel.
DPSC by separate counsel?
Lordship.
Served? District Primary School?
Served. All the respondent has been served. DPSC is respond number 7.
Let the representation be considered within 2 weeks. He's suffering for a very long time.
No.
Yes,
Grateful, madam.
affidavit of service. Paragraph none appears for the District Inspector of Schools. You are appearing.
Lordship.
Only 7.
No.
You are not representing 7.
Respondent who is also separate commissioner of school education. I
2
am
is
only
also separate.
Only for year of school, 8, the year of 7. 7 is also separate council, chairman DPS.
2 and 7 are separate. You are representing others.
Yes.
Yes?
Yes.
None appears for respondent numbers 2 and 7 despite service. Paragraph. The grievance of the petitioner is that though he superannuated on 31st December 2021. 31st December 2021, comma. Pension payment order has not been issued in his favor till date. Stop. The petitioner was initially appointed as a night guard at Shishu Niketan Junior Basic School, comma, Shodor East Circle, comma, Jalpaiguri, on 1st January 1980. And was transferred to the office of the sub-inspector of schools, sub-inspector of schools, comma, Shodor East Circle, as a Group D staff and then to Marwari, M-A-R-W-A-R-I, Marwari Balika Vidyalaya, Din Bazar, Jalpaiguri. The petitioner submitted a representation before the concerned authority on 24th April 2023 seeking issuance of pension payment order and disbursement of pension and other retirement benefits, which has not been considered till date. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest and disburse all retirement benefits in his favor. Stop. Paragraph, learned counsel for the state respondents submits that who should be the authority?
Actually, respondent number 2 is a authority because sanction is awaited from the respondent number 2 of the state post.
Commissioner of School Education. But the that is sanction, but representation will be considered by?
Considered
Yes.
by DI.
DI of
DI has already forwarded to commissioner for necessary accord.
has been forwarded.
Lordship.
You have
Yes,
instructions.
Lordship. Last, last.
He will not last week upon consideration. You're Ramchandra Shah.
Yes, my lord.
Petition.
Petitioner.
Learned counsel for the respondents submits, on instructions, that the service of the petitioner was approved by the secretary, ad hoc committee, DPSC, Jalpaiguri on 2nd February 1995 and his pension file was forwarded to DDA, Jalpaiguri on 16th December 2021, who returned the same upon raising objection to the effect that, what is this SE department?
School education.
School
Department.
Education Department.
School education. Department.
That school education department approval of, raising objection that approval of the school education department was required. Stop. The matter is pending approval before the Commissioner of School Education, West Bengal, being the second respondent herein. Paragraph in view of the same, The writ petition is disposed of, directing the second respondent to accord the necessary approval in favor of the petitioner and this will be communicated to
You committed to DI. Yes, DI school.
DI respond number.
and communicate the same
Respond
to
number eight.
the eighth respondent
Lots of.
to the district inspector of schools, comma, primary education, comma, being the eighth respondent hearing, comma, within 2 weeks, approval or 1 month,
1 month.
approval
My
to
lord,
take time.
Because they have to also praise the matter. 1 month.
My lord, pension matter, my lord, they are facing very hardship.
Let
to
the
delay.
approval come within 2 weeks. And then the payment within 1 month thereafter.
That is approval is.
Yes.
come within 3 weeks times.
Within 3 weeks from the date of communication of this order, stop. Upon receipt of such approval, comma, after the approval comes, the pension PPO can be issued.
Issued.
That is by whom? By the DI of schools?
No, people will be issued by DDA. DDA.
DDF,
Right of
director of account, that is, my lord,
respond number.
respond number 6. Deputy Director.
As upon direction of the DI of schools.
Yes, DI will communicate. To DDA.
The eighth respondent is directed to communicate such approval to the sixth respondent within 1 week of receipt of the same. Stop. The sixth respondent, comma, in turn, comma, shall is directed to, shall not, is directed to issue pension payment order in favor of the petitioner within 3 weeks
Yes.
from receipt thereof.
My lord, I would like to submit one more thing, madam. My lord, that the colleague of the petitioner whose appointment also made on the same approval, same memo number, they got their all pensionary benefits. But in my case, they are denying my pensionary return benefits.
Not denying, sanction is available.
The approval was pending. The instruction says so.
My lord,
It
kindly-
has to be individual approvals, isn't it?
No, it is in one set. Kindly
No,
see
no, that
page
is
number
separate.
30, my lord. Page number 30, annexure P1.
That is approval of DPSC.
Here. Here 5.
This is 1995 service approval.
Yes.
This approval is different.
But
The second respondent has to approve your pension papers.
yes, my lord, but here the five employees appointment has been approved.
This
in
is
which
approval of
service.
service, not pension documents. That approval is different.
Yes, my lord.
ওখানে যেটা বললাম ডিসবার্স নাকি বলে ইস্যু পিপিও বললাম তো ইস্যু pension payment order and take necessary steps for disbursal of all retirement benefits in favor of the petitioner within 3 weeks. ওটার মধ্যে বললাম। যেটা issue pension payment order within 3 weeks issue pension payment order and take necessary steps for disbursal of all retirement benefits in favor of petitioner within 3 weeks. Yeah. Disposed of?
Grateful, my lord.
Yes.
Number 50.
Yes.
Yes, ma'am. I am for the petition.
State.
I'm for the state lordship.
Relating to interest on gratuity below under revised law 2019. Revised. Interest on gratuity.
Question. Revised.
Revised.
Please check the orders as and when they are passed,
Yes.
not these orders. When I am passing orders,
There
please
is
check
any-
them when they
there
are on
is
the
any-
website. Yes. And inform me by Friday. By Thursday, in fact.
Ah.
Yes.
Revised
For the state.
Revised,
2019. Revised.
revised.
15 minutes same revised 2009.
State,
Yes, lordship.
revised.
Same revised 2019. Interest and gratuity.
Revised people. Give your names, state. Revised people.
I'm for the state lordship.
Revised people. State.
I'm for the state lordship.
Revised people. Same order, Mr. Shah? Revised people.
I'm for the state.
State.
Yes, madam. I'm for the state.
Revised people.
I'm for the state.
Revised people.
I'm for the state.
You retired after 19. Revise speaker.
I'm for the state lordship.
Revise speaker.
I'm for the state lordship.
Yes.
I'm for the state.
Yes. Revised. State.
I'm for the state lordship.
Revise speaker.
I'm for the state.
Revise speaker.
I'm for the state lordship.
Revise speaker.
I'm for the state.
Revise speaker. On prayer of the petitioner, the matter be placed before the next available circuit bench.
Next.
I'm for the state law.
Revised. Revised. People.
I'm for the state law.
Single people.
I'm for the state pilot.
Revised. People. Revised PPO. Died in harness? No, after retirement. Rashid? Petitioner is the widow of the petitioner husband was appointed. No?
I'm for the state law.
Petitioner. Single PPO.
Forty-three, my lord, and the state response.
Petitioner. Anyone for the petitioner? 43.
Your the Friday, your lordship was inquiring this representation of the people's side, my lord. I have
Oh,
brought.
this is a election petition
Not election petition, read petition. Pertinent to election.
pertaining to
Three-
panchayat
three-
election.
three-tier election.
Petitioner is not there. Next circuit, let them decide.
Lord, in one order, the others, all the read petition will be followed by the same order, my lord. May I place and then subsequent lordship kindly.
I have seen the acts. I have seen both the acts.
Yes, lordship. So,
So
and
it will
also
not
the
be covered by the Representation of People's Act. I have seen. Yes,
43.
43. This is an election petition. So this court will not have determination. You'll withdraw. You withdraw and approach the appropriate forum. There was a mistake in that. This is not covered by the Representation of People's Act. Isn't it? This is covered by the Panchayat Act, where the appropriate authority is the Civil Judge Junior Division.
And
In
district judge.
case of district judge, in case of
Jila
Jila
Parishad.
Parishads, and for Panchayats is the Civil Judge Junior Division. So you have to withdraw and approach the appropriate forum. This will not be assigned by the Chief Justice. That is up to the principal bench, I cannot make a comment on that. They were all assigned to him, her. And that bench deals with panchayat matters. Now, what other bench does is not my concern at all. It's beyond my jurisdiction. Yes. These are all matters pertaining to panchayat elections. Yes. So the act is very clear. Please give me the relevant provision of that.
Yes, Lordship. First, Lordship,
Who is taking up the matter? Have you seen the act? No, this is the Representation of People's Act.
Madam.
Let me shift these matters to the next circuit. Maybe the other bench will have some other.
Malad, then let me, Malad, kindly see. These are all the serious applications filed. All the officers and the districts magistrates even are concerned with this, Malad. So kindly record my submissions.
Disputes as to elections. The act is very clear on this. I have no control over the principal bench.
Why you are referring to the principal bench?
Let So on your prayer, I'm shifting it to the next circuit because I will not decide. He has a different point. Let us see what the other bench says. On prayer of the petitioner, the matter be placed before the next available circuit bench. I do not know whether those matters are assigned to that bench.
No,
Because
my lord.
election matters are being taken up by a principal bench.
No, my lord.
We are all aware.
No, my lord. It is the election, not election matter. My lord, may I clarify? My lord, when the circuit bench was not in season, my lord, during that period, the principal bench was having the jurisdiction of these districts, including the other districts of the state of West Bengal, my lord. Then in the meantime, the separate application, REIT application has been filed before the principal bench, my lord. And my lord, Justice Sheena was having the determination of the panchayat relating matter, my lord. She is taking up the matter with regards to the other districts or within the state of West Bengal, not pertaining to the circuit bench matter, my lord. Now, the question is that here, my lord, there are series of the REIT petition has been filed. My contention is that, my lord, as I have already indicated, my lord, in view of this Panchayat Act, my lord, these appropriate court is the Civil Judge Junior Division and the Jila Porishad. Then this would be
what he says is to be taken into consideration. Matters relating to panchayat elections are also being taken up by the principal bench.
My lord, with regards to the, my lord, kindly see.
Maybe any district, that is not important.
My lord, kindly see.
Election matters.
Not election matters, my lord. These are all the applications of the REIT applications, my lord. Election petition parted into the parliament and the state legislature.
REIT application with regard to panchayat.
REIT application with regards to a panchayat, my lord.
Panchayat election.
My lord, your lordship is having the same determination. Your lordship is sitting in this circuit bench, my lord. Now, my lord, kindly see whether the principal bench is having the determination taking up with regards to other district and what would be the outcome of the result. My lord, that is a separate.
This is not the question of other districts. This is the question of election petition of any district.
My lord, it is not an election petition. My lord, kindly appreciate.
It is not, the nomenclature is WPA. But it pertains to panchayat election.
My lord, even the panchayat election, then panchayat election, if it is a election petition, then to be filed before the civil judge or the district judge, my lord.
In the principal bench, matters relating to panchayat election are being taken up as WPA. You are aware. That is his submission.
My lord, I am also aware.
That's
but
why,
my lord, it is not a question of the principal but the circuit bench having the same determination, my lord.
Absolutely.
My lord, your lordship will
When
decide.
some of the panchayat election, some of the writ petitions pertaining to panchayat election are being taken up by the principal bench. That is exactly the submission of learned counsel for the petitioner. Then why can't the circuit bench take up? But the law is a bar. I do not know what is happening before the principal bench.
My lord, it is the circuit bench rules specifically states, rule 4, my lord, perhaps, that pertaining to these districts, The circuit bench is only the having the jurisdiction, my lord.
Absolutely, no quarrel with
No,
that.
yes, my lord. Then, my lord, now the matter, suppose now on the same issue, suppose now on the same issue, not an election issue, in the same issue, if it is decided by the principal bench, and the same issue will be decided by this the circuit bench also, my lord. Now, your lordship, the petition has been filed. I am agitating these petitions to be filed before the forum. Now, your lordship is to decide whether whether the 226 application can be entertained or not, or whether it will be treated as election petition to be filed before the district judge having jurisdiction.
The
So
law
this is the
says so.
the law
The
says
law
so.
says so, but learned council's grievance.
No, it is the grievance, my lord. My lord, kindly decide then, my lord. It may be a grievances. So I'm not in that point. He says the principal bench is taking up the matter. Very good. Principal bench is taking up the matter. Lordship will decide the matter. Now, whether the same petition under 226, the
Now, I
petition.
do not know whether the matters are being directed
No.
by the principal bench or they're assigned to the principal.
No, my lord. No, my lord. I with the instruction.
Also. So there will be a conflict of decisions in that case. But as I find from the law itself, I do not have the jurisdiction. So how can I go beyond that?
Then what?
Even when the law is staring at my face? Even when the law is staring at my face? That's why since I'm going to pass an order which will not make you happy, I wanted to shift it to the next circuit. The only reason. I have not really have to dismiss them on the ground of maintainability. Simple. I have to just pass a 2-line order quoting the section, the provision.
Yes.
That's why I give them the opportunity to get an adjournment, take an adjournment. Simple. The other bench may have a different view.
Not law, even when the law is clear, no judges cannot take a different view.
Despite the law being clear, matters are being heard.
That is my lord.
That is their submission.
My lord, I will not make.
I will not make a comment.
Also, I will not make a comment also. But when the law is clear, my lord, how the read petition can be entertained at all?
You can either withdraw or have to dismiss. These are the two.
Then you decide. Yes.
Let it be placed before the next circuit. I'll keep the issue of maintainability open. I'll keep the issue of maintainability open.
This court is also honorable judge of a prince. I do not know why you are referring the honorable judge as principal bench. It should not be.
Please, let us not take him amiss. He is only pointing out that one of the courts is taking up the matter. So why not this?
That
is his submission. He is not referring to or drawing.
My lord, kindly see. Not only election, not only election matter. My lord, any matter. Suppose on the same issue decided by the principal bench, and this on the same issue is decided by the circuit bench. Now this is a conflict of opinion by the definitely.
Refer to a larger bench.
They will refer to the larger bench. Then definitely your lordship has to decide. And they are here, our lordship also to be decided. It must be decided on the point of law, on the point of maintainability. Then it should be to be decided by the larger bench. That is my only prayer.
Since earlier matters which are earlier filed are going on before the principal bench, let them take an adjournment. I'll keep the issue of maintainability open. I'll record your submission.
Lordship.
At the outset, at the outset, learned counsel for the respondents challenges the maintainability of the writ petition in view of the provision laid down in section.
Section, my lord, 90, 93 and 94 of West Bengal.
I cannot transfer, sir. Does this court have the authority to assign?
Please.
You can withdraw, place it before the Chief Justice, get it assigned. That should be on your prayer. You can withdraw the matter and do anything you feel like. If you want to withdraw, you can withdraw. and get it assigned? Yes?
Sorry.
No. Because you will face difficulty. Yeah,
70.
the relevant provision. The law is very clear, very, very clear on this issue.
আমার লিস্টে দাও, আমার লিস্টের সামনে রাখো। বসে দাও।
You are challenging the validity of the election.
Yes.
That is valid.
Yes. Recounting of the
Because-
report.
In view of, in section 79 of the West Bengal Panchayat Elections Act, 2003, which demonstrates that in the event any dispute arises as to the validity of an election under this act, A capital comma, the matter, no, comma, the matter, take it over. The civil judge having jurisdiction where such election is in respect of a Gram Panchayat or a Panchayat Samiti, where such election is in respect of a Gram Panchayat, bollam agar, or the Panchayat Samiti, and the district judge of the district where such election is in respect of a Zilla Parishad or the Siliguri Mohokuma Parishad shall have jurisdiction to deal with such matters upon a petition being filed by the aggrieved party. Stop. Paragraph.
Well, kindly see the 243(o)(b) of the Constitution.
These points ought to have been agitated before the principal bench also.
It's a constitutional provision.
Learned counsel also parana, একই সাথে চলবে।
Kindly
Para na,
record,
same paragraph.
kindly
Learned
record my
counsel-
name, my lord, kindly record my name there, my lord, please.
শুরুতে যেখানে learned counsel for the respondents বললাম, হ্যাঁ, ওখানে মিস্টার ওনার নামটা রেকর্ড করুন।
জয়জিৎ চৌধুরী।
শুরুতে, হ্যাঁ, ওনার নামটা রেকর্ড করুন। Learned counsel also places reliance on Article 243(o), O within bracket small b of the Constitution of India, which says that no election to any panchayat shall be called in question except by an election petition presented to such authority and in such manner as is provided for by or under any law made by the legislature of a state. Paragraph. Learned counsel for the petitioner seeks accommodation. Paragraph, the matter be placed before the next available circuit bench. Paragraph, the issue of maintainability is kept open.
Has to be decided, yes. Grateful.
Kept open, thank you.
Yes, lordship. Lordship, the, all the pertaining to the theater election. Sorry,
Yes, what are the other matters?
my lord, may I? 43, this is the 43, then 52.
Same, who is appearing for the petitioner in 52? Same matter? 52 the same order হবে, mark করো। যেটা দিলাম, হ্যাঁ, হ্যাঁ, 43 এর মতন হবে।
43, 44.
43, 44
Four.
also same matter? Who is appearing in 44? Petitioner? 44 petitioner? Yes, who is appearing? None appears for the petitioner. 44 এ order করো. None appears for the petitioner. The matter be placed before the next available circuit bench.
Then 52.
52, same matter. 52 এর order টা 43 এর মতন same order. Same as 43. হ্যাঁ, same as 43. Huh?
No, no, election গুলো হচ্ছে only.
Election matters.
Oh, no, no.
52 you said.
Yes.
Yes.
72.
Election matter. 72, same order. এটার মতো। হ্যাঁ।
Then 97. 97 you are appearing.
97 is same order.
Then 121.
121, same order. Same order is being passed. Yes.
121, 124, and 125 you are appearing.
124.
Oh, yes. Yeah. After 124, Miller. 121, then 124.
You are appearing in 124. The same order is being passed. Yes.
Then 125.
125. We have same order. Huh? Yes.
126.
126 also. Yes. Same order.
That's all, Miller. Grateful.
So we'll come back to 45.
আচ্ছা ওই একটু শোনো এরপরে আমি তোরা বলছি যে একটা ম্যাটার থাকবে লিস্টটা
44 বলেছি next circuit. None appears for the petitioner.
প্লিজ
None appears for the petitioner বলেছি। হ্যাঁ।
শুধু আমাকে ডাকবে তার আগে ঠিক আছে
43 এর মতো। বাকি যেগুলো বলেছি ওগুলো সেম আগেরটা বললাম। ওগুলো আগে হ্যাঁ। এবার 45 হবে।
দেখো
Yes, 45. State. 45 state.
I am for the statement.
Revised. Revised PPO. 45.
Is not
State 46. Anyone? 46 state.
Yes, my lord.
You're appearing.
My lord, Mr. Shah is appearing, my lord.
Please,
Yeah,
please.
calculate.
Revised PPO. Revised. 47 revised PPO. যা কি যেরকম করছো না রিভাইজ পিপি
I am for the state, madam.
নাম ডেট চেক করে নেব 48 রিভাইজ পিপিও রিভাইজ পিপি 48 49 single PP. Single PP 50. State, you're appearing. 50.
Yes, madam. Mr. Shah is appearing. We'll give them.
Not today means the next circuit. So come back next circuit. If everybody is not ready. No, not today, not possible. On prayer of the petitioner, the matter will be placed before the next available circuit bench. It's on Monday. Next. On prayer of the petitioner, the matter will be placed before the next available circuit bench. 53. Oh, 53, it will be not today because a wrong number has been printed. 53. This has been ordered to be placed on the, in the next circuit, so this is a wrong. But a no order be passed for 53. 1707, the next circuit is order. So no order be passed for. 54. Yes. Who is the employee? Died in harness? After retirement? Petitioner's mother was the employee. देखेंगे बेटा को जीएश माने died after retirement. This is single BPO. Revised BPO. Petitioner's mother was the employee. We ordered to give. Next.
I'm for the state.
Single BPO. Petitioner's husband was an assistant teacher. Single BPO. Single PPO, 2002 retirement. Single PPO. Next.
I'm for the statement.
Interest and gratuity and area payment, যেটা হচ্ছে সত্যি, হ্যাঁ? Revised PPO. Petitioner was the employee? যেরকম হচ্ছে। Single PPO. Single PPO. Single PPO. Petitioners. You've written petitioner in this. Petitioner বলা আছে order টা ভুল আছে। Petitioner's mother was appointed as a teacher. Single PPO. Yes. Petitioner was the employee? Single BPO, 58. Yes. Revised PPO. Petitioner is the employee? Revised PPO.
I'm for the statement.
Actual payment of disbursement for minus 2022, but type of acquisition is minus 20%, 2021.
Where is it? Prayer portion? Yes. Listen. The date of the PPO?
Yes, ma'am. Actual date of payment minus 2022, but minus type of acquisition is minus 2021. And only date is minus 2022. Date of payment.
On prayer of the On prayer of the petitioner, liberty is granted to correct the list of dates and paragraph and paragraph 12 of the writ petition to the effect that the date of payment of gratuity and area amount be read as 22nd April 2022 in place and stead of STEAD, no, in place and stead of 22nd April 2021. This is revised. 60? This is 60. Single PPO. তারপরে অর্ডারটা হয় প্যারাগ্রাফ কথা single PPO.
Melody disposed of it.
Disposed of? Only the correction has to be made, the date. Yes. Revised PPO died in harness. So died in harness with gap dash গুলো দেবে না আলাদা আলাদা। ঠিক আছে আছে অর্ডার সেম আমাদের। Yes, next. State your opinion. Single PPO. Next. Revised PPO. State your opinion.
I'm for the state.
Died in harness, revised PPO.
I'm for the statement.
Single PPO. It was deducted from the PPO or deducted from the PPO? Or she deposited separately? So not deducted from PPO? Overdrawal. Overdrawal deposited by TR Chalan. Deposited by TR Chalan. Huh? PPO থেকে deduction হয়নি কি? Yes.
I'm for the state. Well,
Husband of the petitioner was the employee. Husband of the petitioner was the employee. Huh? Single PPO.
What one, my lord? TR Chalan.
State
I'm for the statement.
overdrawal by TR Chalan. Revise PP. Revised PP.
What one, my lord? TR Chalan.
Overdrawal through TR Chalan. Revised PP. Single PP. Yes. Overdrawn through deposited through TR Chalan. Petitioner was the employee.
Yes, ma'am.
Conversion from CPF to GP. State revised PP. Next.
What one, my lord? Husband of the petition, why then?
Husband of the petitioner was an employee.
Yes.
Husband of the petitioner was the employee. Overdrawal
Yes.
through TR Chalan
No, my lord. Okay, okay.
from PPO. Overdrawal deducted from PPO. Husband of the petitioner. Employee.
What one, my lord? TR Chalan.
Overdrawal refunded by TR Chalan. Yes, state. You're appearing. Single PP, died in harness. Petitioner is the employee. Revised PP.
For the statement.
Single PP. Overdrawal refunded through TR Challan.
I'm for the statement.
Overdrawal refunded through TR Challan. Go for the
Yes,
state.
ma'am.
I for the state.
Revised PP. Revised PP. Yes. Single PP. Died in harness, revised PP. State. 89 single PP. CPF PGP. আমার অর্ডার দিতে করবো কিন্তু আমার অর্ডার না আমার অর্ডার দিতে করবো
Lord, I'm for the statement.
State.
I'm for the statement.
Revised PP. Revised speaker.
But my lord, deducted from.
Yes, this is.
Deducted from, what my lord, deducted from PPA.
Yes, please come back at 2 p.m.
3. আমি লাঞ্চে গেলাম, বাই বাই। বাবা যেটা হয়েছে আবার তো ভালো হয়। এখানে আমার হয়েছিল কত 42 কত হয়েছে 42 কত হয়েছে
तो एडवोकेट का नाम लेना चाह रहे
তো প্রথম হলো
I'm for the state lordship.
Refunded through TR Chalan. Jayanta, overdrawn refunded through TR Chalan. State, unit is.
I'm for the state.
Yes.
My lord, 96, I'm for the petitioner, my lord.
I'm for the state lordship.
My
Yes.
lord, this is an application under 226 filed by the petitioner. My lord, first of all, the petitioner is the ordinary citizen of West Bengal and belongs to a scheduled tribe, my lord. My lord, first of all, I'll draw your attention to annexure P1 at page 14, my lord.
14.
14, annexure P1. My lord, this is
Yes.
the Constitution Schedule Tribes Order 1950, my lord. My lord, in its subsequent page, West Bengal Part 8 is indicated, my lord.
Yes.
Throughout the state, item number 6 is Orao. This is the tribe that has been scheduled by the constitutional order to be a
Yes.
scheduled tribe. My lord, subsequently, there were certain amendments, but the Orao tribe stayed, my lord. That is at page 17. Constitutional order was amended, and subsequently at entry number 17, Orao tribe has been given a place. My lord, considering this fact, the petitioner applied for a scheduled caste certificate before the concerned subdivisional officer as per rules, my lord. My lord, thereafter, to the shock of the petitioner, no action was taken, no progress was made. And on fine day, when he was inquiring in the official website, my lord, amazingly, if it could come to page 43.
Yes.
My lord, it says that my application has been rejected.
You were not given a hearing?
Nothing, my lord. Nothing was given to me, my lord. My lord, then I would like to draw attention to the.
43 is, it's a status report.
Yes, my lord. That is the status report of my application, my lord, that has been made online. And you
Yes.
see, my lord, first column
Where is the
says,
rejection order?
ma'am, this is the only thing available to me, my lord.
43.
Yes, my lord. Status applicant rejected. Application rejected. Now, my lord, I would like to draw your attention to the law that is.
Discrepancy in applicant's name in application and supporting documents. That's the reason.
That is the reason they have stated, my lord. There is
Yes.
nothing such, my lord, because, my lord, the next page kindly see. 45.
Yes.
My lord, my daughter made an application with me.
Yes.
My name is there as Priksha Tirke, daughter of Krishnu Tirke. A certificate has been issued in her name.
You are Krishna Tirki.
Krishna
Your
Tirki.
father is Shivu Orao Tirki.
Yes, my lord.
What? Where are your other documents that you have placed along with your application?
My lord, I am not required to place any document, my lord.
You had placed supporting documents.
Yes,
What
my
are
lord.
they? What are they?
My lord, my Aadhaar card is there at along with my application, my lord. It is at next to P2.
Page?
Page 18, my lord. 18. There is a memorandum issued by the government of West Bengal, how these applications are to be considered, my lord. My lord, that is annexed at page 25, annexure P6.
Yes.
Madam, this is an updated guidelines for issuance of SC/ST certificate. My lord, without wasting much time, my lord, I would take my lord's attention to page number 27, 28, my lord, particularly.
Yes.
Note 2, it is mentioned there that has the right to appeal even without any documentary proof in support of his claim, and no application shall be rejected merely on the grounds of non-availability of document evidence about caste identity, residence, or citizenship. My lord, my citizenship is not in question, my caste not in question, my residence is not in question. There is no scope of rejecting my application, my lord. They have given a further, in case certificates of the Pradhan Panchayat can be called for, these they have
And
to.
you were not heard prior to this
Nothing, no,
rejection.
my lord, nothing. I was not even communicated that my order, my status has been rejected, my lord.
Let us hear the.
My just submission, my lord. I had suffered an injustice, my lord, atrocities against me. I had to lodge a complaint before the police station. Now, my lord, the investigating officer is constantly asking me to produce a certificate, and I cannot produce because of this status, my lord. And if because of that, the entire case is pending since 2019, the police is unable to submit a charge sheet. This is my difficulties, my lord, that I've filed an appeal before the DM. There was 3 months time to dispose of that appeal by the DM. That also has not been considered. No notice has been served.
Appeal against this order.
Appeal against this order, my lord. I have appealed in the month of April. 3 months have passed. That is the statutory limit to dispose of an appeal. That too is not been done, my lord. I am suffering. That is what I had to invoke the writ jurisdiction, my lord. I have no alternative remedy.
Your prayer is for disposal of the appeal.
My
because
lord,
since
my
that
prayer is for
pending-
issuance of certificate, my lord. Prayer B, my lord.
You've taken two simultaneous forums.
No, my lord, nothing is simultaneous. The period is exhausted. They did not dispose my appeal, my lord. The 3 months
Have you
period has
have you
expired.
stated that in your
Yes, my lord, I have stated.
writ petition?
Yes, my lord.
Where is it? Have you stated about the appeal?
Yes, my lord. I have annexed my appeal.
Where is the averment in your writ petition? You've stated that there is no alternative remedy available to the petitioner.
My lord, at para 13, my lord. This was preferred an appeal to the district magistrate on 25/4/2023. Not yet considered by the respondent, and the same is jeopardize the rights of the petitioner as put in difficult situations since the investigating of.
Right, yes. Yes.
Lordship, I go through the writ petition actually. Lordship, it can be considered because he's by birth, he's belongs to ST community. That is my concern, Lordship. So it can be issued, Lordship, because they are showing the discriminatory in the petitions, but there is nothing clearly shown.
My daughter has been issued, by the.
So let it be reconsidered upon hearing the petition. And in the light of the notification.
My lord, in the meantime, maybe I be considered as an ST candidate, my lord.
Unless a certificate.
My
is
lord,
issued,
I
how is it
have,
possible?
my lord, because I have to give something to my investigating officer. Otherwise, my lord, they will file a charge sheet and
They'll
the
consider
entire.
it within 2 weeks.
My lord,
I'll give a
kindly,
direction.
in that meantime, I can be considered, my lord.
2 weeks, sir.
Kindly, my lord.
So then they'll consider within 2 months then, if in the meantime anything happens.
My lord, I'll
I'm
set,
giving them 2 weeks time.
my lord, in the meantime, kindly
No.
protect me in that interim order, my lord.
There is no question of
Just to
protection.
consider, my lord, I am just relying on a judgment of the coordinate bench,
Please
my
show
lord.
me.
Just a privilege. The only in this an interim order was given that the candidate to be considered as scheduled caste, similar facts and circumstances, my lord. That was a scheduled caste certificate. This is a scheduled tribe certificate, my lord. Para 6. Six and 7.
Yes, because the matter was adjourned and the report was called for. I'm disposing of the writ petition itself now, here and now.
I'll bow down,
Isn't
my lord,
it?
sort of.
And this was for participation in a process. This is an
My
issue
my
fact
situation similar, my lord. I have to submit the same before the investigating
So
officer.
participating in a counseling process is similar to,
My lord, I have a
don't
requirement.
you think the
because
fact situation is different in this case?
little bit different, my lord.
Absolutely different. This was an interim order when there was an adjournment of the writ petition, number one. Secondly, this was participation in a counseling, which has a cutoff date, isn't it? So this has no similarity with your case at all.
Strictly within 2 weeks.
2 weeks, of course. You can come back in contempt if it's not complied with. And learned counsel is supporting your case.
Fair submissions.
Absolutely. I don't think I should record your submission. You'll be in trouble. Third learned counsels for the parties. The petitioner claims to belong to the Orao tribe, O-R-A-O-N, O-R-A-O-N, Orao tribe. And submitted an application before the third respondent.
Third respondent.
Before the third respondent for issuance of scheduled tribe certificate in his favor on 13th August 2019. Stop. The petitioner was neither called for a hearing, comma, nor any communication made to him with regard to the fate of his application. Stop. The petitioner learned about rejection of the application from the website of the authority. Stop. The ground of such rejection is recorded as discrepancy in applicant's discrepancy in applicant's name in application and supporting documents. Paragraph, learned counsel for the petitioner submits that no opportunity of hearing was accorded to the petitioner prior to rejection of the application, and the said order was not even communicated to him by the authority. Stop. Learned counsel has placed reliance on the memorandum issued by the Government of West Bengal, comma, Backward Classes Welfare Department on 27th July 2015, which demonstrates that the applicant has the right to apply even without any documentary proof in support of his claim, and no application shall be rejected merely on the ground of non-availability of documentary evidences about caste identity, comma, residence or citizenship. Stop. The petitioner seeks reconsideration of his application and issuance of scheduled tribe certificate in his favor. Paragraph. Upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that since it prima facie appears from the documents annexed to the writ petition. Oh, paragraph 11, upon submission here, consideration paragraph 4, learned counsel submits that the petitioner was subjected to atrocities for which he lodged a complaint before the Siliguri police station, which was registered as Siliguri police station case number 920 of 2019, dated 5th December 2019. Stop. Since the petitioner is unable to produce the scheduled caste certificate to the investigating scheduled tribe certificate, scheduled tribe certificate before the investigating officer of the case, the investigating officer is unable to submit charge sheet therein. Stop. Also, an identical application made by the petitioner's daughter has been allowed by the authority who has issued such certificate in her favor. Upon consideration of the submission made on behalf of the parties, this court is inclined to hold that from the annexed to the writ petition that the petitioner belongs to the scheduled tribe, the and also as there is nothing on record to suggest that opportunity of hearing was granted to the petitioner prior to rejection of his application, the concerned authority should be directed to revisit the issue upon granting reasonable opportunity of hearing to the petitioner. Paragraph. The
My lord,
petition is
even for, if required, local inquiry be conducted as per the prescribed norms.
paragraph. The writ petition is accordingly disposed of, directing the third respondent,
Yes, my lord.
the third respondent to revisit the issue and consider issuance of scheduled tribe certificate in favor of the petitioner upon affording reasonable opportunity of hearing to the petitioner and in the light of the
Page 28.
in the light of the guidelines / memorandum dated 27th July 2015, within 2 weeks from the date of communication of this order. Stop. The concerned authority shall be at liberty to make necessary local inquiries.
Local inquiry.
Local inquiry in order to ascertain the eligibility of the petitioner prior to issuance of, prior to considering the request of the petition. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Dispose of which.
Deeply obliged.
$98. Yes.
No, the state was supposed to.
take instructions.
Yes.
Yes. What is the order passed on 28th September?
Yes, madam. 28 September 2021.
Yes.
Himalayan milk.
Yes, Mr. Shah. A very short issue. Has the order been complied with?
No, no, not at all.
There are so many matters. We have got instruction and certificate that those matters is total. The problem is this, there are total 600 employees of the last person who was looking after the matter, he also is deciding the last one. So it takes some time to do the stuff. And it's known to my friend of that person is neighbor. So I want this to opportunity.
Malad, there are, so if you also can see prayer, Malad, all these are pending, Malad,
Yes,
since
but
the redeployment,
we have
Malad.
already complied number of matters.
Malad,
For this matter to follow up, we have to do.
this has to end within a stipulated time, Malad.
So the last person who was there among the chief engineers.
If you also can see
So
page
it has to be
70.
approved, released by the Principal Secretary Finance. Then the Animal
Yes,
Resources.
fund
Department
has to be sanctioned, then the DM will
Release.
disburse the yes.
Come back, he has some predicament, come back to the next circuit, next circuit.
Well, kindly makes that observation, Malad, that they are
Which-
praying for
Yes.
next circuit.
Yes. Learned counsel for the respondents seeks further accommodation to ascertain whether the order dated 28th September 2021 has been complied with. Stop. Learned counsel on pair of the respondents, the matter is placed before the next available circuit bench.
Careful, Lord. Malad, next matter, same matter.
Next matter, say
I do not know.
99 same order. An order was passed in this matter also?
Yes, ma'am.
The date is also the same?
Same.
Order date is same? 28th September 2021, remember? Same order. They are appearing together only, one after the other.
Careful, Lord.
I'm appealing for the petitioner, but it is a matter, my lord, where, my lord, as per the notification of the school education department, the supernumerary post was created to, my lord, accommodate the wait list candidate of the state level selection test of 2016. And my lord, this matter is now pending before the Honorable Apex Court, my lord. All, my lord, SLST matters, all are, my lord.
Pending.
Yes, my lord.
So
all
let it
issues-
be out of list. Let it be out of list for the
Yes,
time
your
being.
lordship. Yes, your lordship. Let it be out of list.
In view of the submission made on behalf of the, in view of the submission made by learned counsel for the petitioner, that matters pertaining to similar issues as in the present writ petition is pending before the Honorable Supreme Court, comma, let the matter go out of list.
Grateful, your lordship.
Yes, Lordship, I on with the petitioner, Lordship.
Correction.
Lordship. Lordship, in this more one indulgent Lordship, the cost title last date Lordship order was passed by this court and leave granted to me Lordship, and I not comply with the leave, my lord. My lord,
You have not made the correction.
no, correction, my lord, one again, Lordship, I am kindly leave granted to me Lordship, and I today I comply with this. Order, Lordship.
Why is this matter appearing? It is disposed of.
No, no, Lordship. It's a pending matter, Lordship. The
So
pardoning,
please do the corrections today.
yes, Lordship.
Yes.
And may I, Lordship? Lordship,
Yes. Who is appearing for the respondents?
We are for the. I am for the distribution company.
and Lordship, last day, objector, Lordship, added
Notice
respondent number
upon the-
5.
Added respondent number 5. Have you
5.
served?
Yes, Lordship, I served, but not
Not served.
not served, but their direction.
Who is appearing for the distribution company? You are appearing for the distribution company. And there's a private respondent.
Yes.
Yes, Lordship.
Who is, you are appearing for the,
State responder, I am WB citizen and they are private. You are the director to serve on the private respondent.
the state has not been made a party.
Lordship, canned application has been there, Lordship, as a respondent number 6, Lordship.
That has been allowed.
Yes, Lordship, that has been allowed, Lordship.
So, but the correction is not made.
Yes, Lordship, not.
It is not served. Please serve and come back. The private respondent.
Lordship, I served, but kindly see the, Lordship, kindly see the 8th June 2023 orders, Lordship. Last order, Lordship, 8th June.
Yes.
Yes, Lordship. Land and Council for the state requested to communicate a gist of this order along with a copy of this writ petition to be supplied by the petition to the added respondent number 3 through the Inspector in charge, Bhaktinagar Police Station, Lordship.
Yes, and this is the report of the.
Yes, Lord.
Inspector. That means you've given a wrong address.
No, Lordship, the address given to by the distribution company, Lordship. Same objector, Lordship. Same address,
Objection
Lordship.
for?
Objection for giving connection for the private.
No, we are not on merits at all.
No, I have.
The private respondent has to be served.
Then I have supplied the name of the address from this.
These objector name of address,
You
Lordship.
have to make a substituted service in that case. If you cannot serve in the ordinary manner, you have
Lordship,
to
I have through post service that was not been done.
do whatever.
Then the coordinations of the direction to the state to.
Yes, but since he has not been found,
Yes, Lordship.
so you have to apply order 5 rule 20, you have to take recourse to order 5 rule 20, substituted service. You have to serve, sir.
Yes, Lordship.
Otherwise it cannot be taken up.
Lordship.
Since service upon the private respondent is not complete, comma, the matter be placed before the next available circuit bench. Next.
Grateful, Lordship.
Hundred and two, petitioner? Anyone? Petitioner? None appears for the petitioner, petitioners, no accommodation is sought. The matter be placed before the next available circuit bench. Give your name.
Lord, I'm appearing for the petitioner in 103.
Other respondents?
Lord, jail kundu kyun? 103.
This is the same thing on limitation, it has been dismissed.
My lord, it's. I said objections can be done away with a cup of coffee.
Only a cup of coffee? That's not fair.
My lord, amidst the full functioning of the court, that is the luxury that
You
we
have
have.
to raise your standards a little more.
Lordship.
Only a cup of coffee will not do.
Grateful, my lord. My lord, in this matter also, it's yes, it's a matter of limitation, my lord, 50 days delay. But one small thing remains here, that the penalty order, although passed, the proper show cause notice was not given to me under GSTDRC 01. GSTDRC 01A was given. And my lord, divergent views, I should be very candid before your lordship, divergent views prevail. That some says GSTDRC 01A that conveys the gist of the show cause suffices, constructive notice. Some says that no, GSTDRC 01 should be mandatorily given. My lord, that is the point which I would ought to take before the appellate authority as well.
Right.
So I will not trouble my lord with that. And in this matter, although I'm not, it's not required, Musammat Katiji. Only one small.
The central authority has been deleted.
No, my lord, they wanted to get deleted.
Respondent number 4 is deleted, I find.
They wanted
And
to
that
get
has been done.
Yes. But only one problem remains. That is because anywhere, whenever a due is slated, my lord, the respondent, the CGST takes 50% and the SGST takes 50%. So if today I do not implead them as a party, tomorrow, my lord, they might just simply come back and say that our interest was prejudiced without hearing us.
No, it has not been deleted. It was,
Yes,
he was at liberty to renew the prayer.
True.
So let us go and consider on merits.
My lord. My lord, only one small, lordship knows this is a very famous case and lordship must be knowing this. My lord, this is 1987 Supreme Court 1353. This is Musammat Katiji land acquisition Anantnag. My lord, will kindly come to 1987 Supreme Court AIR 1353. Lordship, kindly come to page 2. But rather page 3. I should straight away go to
Define
page.
sufficient cause.
My lord, those 6 golden principles laid down by the Honorable Supreme Court, saying that a litigant doesn't stand to get anything benefited from his own delay, and a substantive remedy, pitted with the technicalities, substantive remedy ought to be given preference to. And then thirdly, every day's delay must be explained.
These
That
are
does
the
not.
golden rules of condonation. So
So that's all it is, and it's only a question of 50 days, my lord. Lordship will kindly come to the impugned order. I won't trouble your lordship much
at
with
page
this. 53. Effective will be 59 and 60. (59) lordship kindly comes. I'll cite from the ultimate paragraph.
59.
59.
15th February order.
Lordship, it's a 15th February 2023 order.
Yes.
Apart from this, had the appellant become so keen, she could have filed the appeal challenging the order passed on the above adjudicating authority on 13/12/2019 on or before 36/2022. My lord, this 36/2022 is again that date to which my limitation stands extended by the Honorable Supreme Court's order and by virtue of Rule 107(4), Section 107(4), in accordance with the pronouncement of the Honorable Supreme Court as stated aloft. Since the instant appeal that has been submitted electronically beyond the stipulated time clearly suffers from limitation of time, as well as the said reply is not satisfactory.
What is this reply?
My lord, the reply is my reply. Both are there, the condonation of delay at page 46. And they once again issued me a show cause notice on limitation, that is at page 49, and reply to that show cause notice at 51 and 52. Lordship kindly comes to condonation of delay, page 46. Page 46, submit as under.
46 is the
Condonation of delay, which was filed along with the appellate order, appellate memo, the memo of appeal. P6. That on and from December 2020, there was a surge of COVID-19.
Your delay is for 2 years and 5 months, you say?
The delay is only for 50 days, 50 days.
You have stated 2 years and 5 months in your prayer portion. Page 47.
My lord, at that point of time, the order of the Honorable Supreme Court was
Was
not
not
there,
there.
was not there. So thereafter, it is only for 50 days. And this was the condonation of delay, my lord, where the COVID-19 was cited as a
Right,
reason,
yes.
because this was beyond, I mean, before the period of 28 to 2022. And thereafter, my lord, the show cause notice was given at page 49. Lordship
Yes.
wants me to elucidate on this?
No,
My lord. Page 49 is the show cause notice.
and a reply was given there.
And the reply was given thereafter at page 51 to
51,
53,
right.
51 to 52. This reply was given mainly, my lord, the pandemic situation was, cited as the reason, because my dates were within that parenthesis, my lord. So this was 107.1 and 107.4 read together gives me time till 30th of June, 2023. And it was finally filed and disposed of on 15/2/2023. That is the impugned order at page 53. Mainly, may not the impugned order discusses regarding the intention of the legislature. Page 54, Lordship kindly sees. The intention of the Honorable Legislature is much
It's
clear.
entirely on that.
It's entirely on that. And yes, in the show cause notice, it's my duty to show you, Lordship, this is something which is a bit different than other petitions. Page 50, if your Lordship kindly comes to, there is one line in the second paragraph. It's my duty to put forth before you, my lord.
Page 50.
50, second paragraph, the last two sentences, hence the maximum time limit allowed within which an appeal has to be filed is 4 months. The instant application, appeal application has been submitted after the lapse of maximum time permitted by the statute. Here is a small problem, because apparently the statute seems so that it is only for the purpose of 4 months, the authority has the power. But this question, you know, it was agitated in one unreported matter, Kajul Datto, before the Honorable Division Bench of the Calcutta High Court, wherein Honorable Division Bench at paragraph 3, Lordship will kindly see this one. Because since this point has been taken, well, not only that, paragraph 3, page 2, I'm just reading paragraph 3. The correctness of the stand taken by the appellant that he was sick and unable to take steps to file appeal within the period of limitation is not disputed by the revenue. However, the appellate authority was of the opinion that the period of 1 month beyond the statutory period of limitation is available to the said authority, which expired on 30th June 2022. And the appeal was presented only on 17th August 2022, and therefore the appeal is barred by the law of limitation. It is true that in terms of section 107(1), read with section 107(4) of the GST Act, the time limit for preferring the appeal beyond the period of 3 months is 30 days, which is a grace period. However, the statute does not state that beyond the said date, the appellate authority cannot exercise jurisdiction. It is not a case that deliberately the appellant had presented the appeal beyond the condonable period. Therefore, while exercising jurisdiction under Article 226 of the Constitution, this court can examine the factual circumstances and grant appropriate relief, as the appellate remedy is very valuable remedy, since the appellate authority can reappreciate the factual position. Thus, for such reason, we are inclined to exercise that discretion. Milord, not only that, only one thing, Milord, I should propagate, that is the writ remedies, Milord, as far as my knowledge goes, writ remedy, we can challenge the decision-making process.
Right.
We cannot challenge the decision. But in an appeal, we can challenge the merits of the decision. So that way, Milord, it is a way deeper remedy. And if that is carved out, the writ remedy cannot absolve me of my liabilities, Milord. So that's my humble submission, Milord. So this was also taken care of with the Honorable Division Bench's judgment of our principal bench.
Yes.
Intention, my intention is not to raise objection, but just to point out my lord, probably this matter won't be entertainable before the circuit bench because my lord, the place of business is in Malda. And my lord, the officers who have passed the order, my lord, they are in Raiganj.
No,
The appellate authority as well as the adjudicating authority.
Then how before the circuit bench?
no,
It's number 50, my lord.
it's not only that, my lord, the cause title lordship kindly sees.
Yes.
I am having a place of business at page 1, the first page, my lord.
Your registered office is at Malda.
Right, and my branch office where the incident of this seizure took place was at branch office of 4th Mile, Sevok Road, Shalugada, Bhaktinagar. The seizure took place from this godown, my lord. And it's my branch office, designated branch office. And that will be also apparent from annexure P1.
The authorities, my lord, who have passed the
Where?
order are from Raiganj circuit.
True, because that is my jurisdictional appeal where it lies. But the incident of seizure took place here. It is against a seizure, go down seizure.
After the incident, lot of water has flown through.
No, my
the
lord,
grounds.
the seizure.
Finally, you're challenging the appellate authority's order.
No, my lord, the seizure has been culminated into 122 penalty. I am against that 122 penalty only. And once I prefer the appeal, I do not prefer before the Raiganj authority. I prefer the appeal in the portal, and the portal decides it according to its own algorithm.
It's jurisdictional.
Jurisdiction.
But look, that is the appellate authority does not, in my humble submission, it does not determine the jurisdiction. The appellate
No, the
authority.
appeal has been also considered by the Joint Commissioner Revenue, Raiganj circuit.
True, because that is not on me. I cannot choose the appellate authority. The algorithm chooses it. And since my RC, the registration certificate is from Malda, it is giving it out there in the appeal of Malda.
Malda will have jurisdiction of this.
But when the appeal, this
besides the seizure, nothing else has been done within the circuit bench jurisdiction.
Milord will kindly see the order. I'll just show you lordship the order. Siliguri Central Section 32, page 32, my lord. The order in challenge, order under challenge. The penalty order has been passed by DCST Siliguri Central Section, page 35, the designation of the authority. And against this, my appeal was directed. My moot grievance is against section 122 penalty. Page 35 shows the, and it is under the Bureau of Investigation, North Bengal. Page 32, it is same Poribohon Nagar, Matigara, Siliguri.
How is it that this was passed by the Siliguri Central?
Because the cause of action arose here, my lord.
No, my lord, the investigation took place under the Bureau of Investigation.
And the imposition as well. The penalty was imposed by them.
When the appeal was preferred, since my lord, it is a matter, the place of business is under the Raiganj circuit, the appeal went to the Raiganj circuit.
That is algorithm.
No, not algorithm. It is connected with the jurisdiction. But my appeal sitting in Jalpaiguri cannot be adjudicated in both.
But in that case, the Siliguri Central Section could not have dealt with the matter.
True. No, since my lord, it was.
The registered office is at Malda.
Yes, but my lord, since the place of incident, the interception happened within their jurisdiction, they conducted the investigation. Subsequently, the case records were transmitted.
So for the same reason, I think this court can deal with the matter.
I think a part cause of action is there.
The cause of action arises from Siliguri.
See, if there's a part cause of action, then this court has.
True, my lord, true.
On merits, Mr. Ghosh,
Let us consider the appeal.
let it be reconsidered.
Let it be
right? Wait.
Great.
The order passed
Page
by the
53. Oh.
passed by the appellate authority 15th February 2023.
15th February 2020.
On 15th February 2023, dismissing the appeal preferred by the petitioner, comma, on the ground of limitation, comma, is assailed in the writ petition. Paragraph. A consignment belonging to the petitioner was intercepted and detained on July 10, 2019 by the revenue in Siliguri town. And upon necessary inquiry made by the authority, comma, the petitioner was directed to appear before the appropriate authority and produce books of accounts for the period 2018-19 on July 25, 2019, comma, by a notice issued by the authority on July 16, 2019. Stop.
Well, both periods, 1819 and 1920.
You've stated 1819 in your writ.
1819 and 1920. It's apparent from page 31, Lordship.
Mm, 2018-19 and 2019-20 you should have.
My lord.
You were heard prior to this order.
Which order, my lord?
You complied with the notice.
122, yes.
And appeared before the authority.
Yes, I
The page
appeared.
32 order.
Yes, I did. I appeared, I submitted before that authority.
Stop. Upon hearing the petition, upon hearing the petitioner and considering the relevant material placed before the authority, comma, the concerned authority, comma, by an order passed on 13th December 2019.
My lord.
Levied penalty upon the petitioner to the tune of rupees 97,225.
97,225, my lord.
Yes, 97,225, comma, payable within 31st January 2020. Stop. The said order was carried in appeal by the petitioner along with an application for condonation of delay of about 50 days. Stop. The petitioner was served with a show cause notice directing him to explain the said delay. The petitioner was served with a show cause notice যেখানে বললাম on 2nd February 2023. On 2nd February 2023, directing him to explain the said delay. Stop. The petitioner sent a reply to the notice on 8th February 2023. Please correct me that I go wrong. with
Lordship,
dates.
I'm following my lord's dates, my lord.
Stop. By the order impugned, dated 15th February 2023, comma, the appeal preferred by the petitioner was dismissed solely on the ground of limitation. Stop. Merits of the petitioner's case were not considered by the authority. Stop. Paragraph. Paragraph. The order passed on 2nd February 2023 indicates that since the maximum time limit allowed within which an appeal has to be filed is 4 months, comma.
The show cause notice.
Yes,
Show cause notice.
this is the show cause.
Show cause, it's the gist of the order proposed to be passed, annexed with the show cause notice, 2nd February 2023.
কি বললাম ওটা শুনতে পাবেন? Order না, the show cause notice dated 2nd February. The show cause notice dated 2nd February 2023 indicates that since the maximum time limit allowed within which an appeal has to be filed is 4 months, and the application has been submitted after lapse of the maximum time permitted by the statute, comma. The same cannot be considered. This issue has been dealt with by an honorable division bench of this court, presided over by the Honorable the Chief Justice, in MAT number 1924 of 2022, and by an order passed on what is the date of the order?
Lord, delivered on 21/2023, January 2023 at the first page. At the very
Passed
first.
on 20th January 2023, comma, the Honorable Division Bench held as hereunder, colon dash. It is true, okay? Exercise discretion. এইভাবে mark করে দিন। Paragraph. In the present case, comma, it prima facie appears that the appeal was referred after a delay of about 50 days. Stop. in view of the observation made by the Honorable Division Bench as referred to earlier, comma, this court is inclined to hold that the appellate authority be directed to reconsider the appeal on merits upon condoning the delay in preferring the same and upon affording reasonable opportunity of hearing to the petitioner. Stop. The writ petition is accordingly disposed of. Oh, no, we'll enter everything. The order passed by the appellate authority being the Joint Commissioner of Revenue.
Joint Commissioner.
Being the
respondent number
Joint Commissioner of Revenue, comma, Raiganj Circle, comma, Raiganj, on 15th February 2023 is set aside. Paragraph, the writ petition is disposed of, directing the concerned authority being the respondent number,
2, my lord.
being the second respondent herein, comma, to reconsider the appeal preferred by the petitioner upon affording
On merits.
upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, and pass a reasoned order within 1 month, Mr. Ghosh?
Yes.
Within 1 month from the date of communication of this order, comma, in accordance with law.
My lord, I'm grateful to you, lord.
Disposed of, is it?
Great. And the usual paragraphs.
Yes, absolutely.
Great.
It is approved.
Grateful.
Next. Petitioner? Anyone for the petitioner? None appears for the petitioner. Stop, no accommodation is sought. Paragraph, the matter be placed before the next available circuit bench. Four.
Oh, no.
I am for the petitioner. Single PPO.
Again PPO. Petitioner is the employee?
Yes, my lord. No, my lord, died in harness, my lord.
Died in harness.
Yes, my lord. Petitioner father was an employee.
Shorju, petitioner's father was an employee, died in harness. Single PPO.
Yes, my lord.
I'm for the statement. Yes.
My lord, this is my service is not complete.
Since service is not complete, let the matter appear before the next available circuit bench.
I am for the petitioner. My lord. Interest of debit and arrear function, my lord. Single PPO.
State?
Petitioner father was died, my lord, after retirement.
After retirement.
Yes.
State? No one received. Served.
My lord may pass necessary orders.
Who will appear?
If my lord direct, I can appear.
Single PPO.
Yes, ma'am.
Petitioner's father was the employee.
Yes, ma'am.
Raju. Next.
Hey, again, the number of single limited.
108.
My lord, 108, my lord.
I appear on behalf of Mineral Development on last occasion, Lordship, the learned advocate representing the state. The Lordship asked him to obtain instruction as to who is the competent authority to consider the representation of the petitioner.
Yes,
My lord, 108, I am appealing on
Lordship,
behalf of-
your lordship has disposed of numerous writ petition directing the concerned ADM of that district to consider the representation.
yes.
Because the lease was executed by and between
No,
the
this was
writ
made not to be
petitioner
on the
and the district authority.
Yes, petitioner?
My lord, I am appealing for the petitioner. my lord.
Yes.
It was made early on earlier occasion. It was made not today because the learned additional advocate general took short time to see if similar matters are passed by this court or not. My lord, I asked my junior friend here to give me the case numbers of similar matters so that I can ascertain whether similar matters are passed or not. But he has not given me any case numbers yet.
You've not given the numbers.
Lordship,
I am not served any similar matters by my senior lordship.
Taken up tomorrow at any time.
So it's being passed. Senior has not served.
In similar matters.
Mr. Shah, the state is in little bit of
What can be-
confusion because he is not aware of the earlier orders. So let him have the
Yes.
numbers, let him consider. Bad luck, next
Lordship.
circuit.
My lord, this matter has been adjourned for so many days, my lord.
Yes, but you have not given the numbers of the similar
Milord,
matters.
if I may, Milord,
No, my lord,
That is what your junior friend says here.
no, my lord.
You're for the petitioner, isn't it?
Yes, Lordship. Led by Mr. Dipankar.
Now, Lordship, may I
Yes.
just indicate one thing, Lordship?
No, my
On the
lord,
last
there is some
occasion, it was
confusion.
submitted on. Your Lordship, on the last occasion, I submitted before your Lordship that the ADM of the concerned district, who is the appropriate authority to consider the representation of the petitioner. On the other hand, the learned advocate representing the state, he submitted that the representation may be considered by the mineral development. So, see, the difficulty is the lease was executed between the district administration and the writ petitioner. So, the 2021 rules came into effect after the lease was
That is
executed. So
prospective.
what?
That is prospective.
Yes. So that cannot have retrospective effect, and mineral development cannot consider the
Lord, I am not
representation.
supposed to get any
So it
feedback.
is
by the
for the
ADM, the
Yes,
district,
the
district land and
ADM
land
has to
reforms
consider.
officer.
That was
Yes,
the confusion on the earlier
it
date.
can be done.
Yes,
I
yes.
Yes, exceeded to,
Yes, ma'am.
Yes,
exceeded
Lordship,
to by
that-
learned council. That was
and
not.
Lordship, is it possible to indicate that the matter was taken up consideration on 4th of August? And in terms of the liberty granted, the instruction is furnished by the learned advocate for this state.
Very well, very well.
Yes.
I absolutely understand.
Yes, yes. I'm grateful to your Lordship.
The matter was taken up for consideration on 4th August 2023. And on prayer of learned counsel for the state respondents, liberty was granted to ascertain who should be the authority to consider the representation submitted by the petitioner. Is that all right? Yes,
Yes, Lordship, that will.
paragraph. The petitioner no, being the highest bidder in the e-auction floated by the authority and upon depositing 1/3 of the bid amount, the petitioner was granted long-term mining lease for a period of 5 years. You are asking for execution of deed.
Yes, my lord.
Deed was not executed.
No, my lord. Till that did is not been executed. Several representations sent, my lord, from
Yes, yes. Being the And letter of intent was issued in his favor. Stop. The petitioner obtained environment clearance certificate from the district level environment impact assessment authority, Jalpaiguri, on 3rd March 2017, along with the mining plan. The petitioner is ready and willing to deposit the remaining bid amount and approached the concerned authority for execution of deed of lease in his favor. Stop. Several representations submitted by the petitioner in this regard fell on deaf ears. Fell on deaf ears. Stop. Fell on deaf ears. DEAF-EARS. EARS. Stop. The petitioner seeks a direction upon the concerned authority to consider his representation dated 2nd August 2022 at the earliest. Paragraph, it is submitted on behalf of the respondents that the 4th respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the 4th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month. Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of, judgment.
Grateful.
I'm for the respondent of Guri municipality.
You are the only respondent?
No, my lord.
You are the municipality?
Yes, I am for the municipality.
The state is also there. You are, he is appealing from state? State? You are appealing? What about the private respondents? Where is your affidavit? Yes, that. This is service of the substitution application. Yes, there are some. Yes. Yes.
They have also started pillars. In the land which belongs to or has made constructive part of the houses or the system and the family members the all the stopping all the government and also the after capital on the minute problem implement the paper besides the construction has been made over after the legal
Why have you implemented the municipality? Yes.
Admit that the land before the construction has been made as a business is a government side. Kindly comes the second part of into of the directly and responsibility that to consider according to after all the nothing for nothing for wide inspection ascertain the relativity of the elevation of the picture.
Yes.
After passing of paper, I communicated to say to the respondent, page 21 is communicated. You are certified page 20 your lordship. And find the respondent number 9 your they state a letter to me. Here, the undersigned will not draw attention to the about that the mention that mention about in the application. That's what for my picture. Here, last order they were admitting the land was under their now they are ignoring the order of the state. All the was they will be ignored by the
Where is your contempt application? The order has not been complied with.
Order is not complied. They have put a letter to picture. They have
Contempt is on a subsequent event only, isn't it? When the order is not complied, you have not filed a contempt application.
And they just now they are denying that land does not fall under this.
Who admitted? The private respondents at the council admitted. Yes, yes. Oh, both are occupying private government land. Let us hear the state. Yes.
My lord, for municipality, I have a report, my lord. All that time. In the which order hope in the
Please give a copy to the.
yes, madam, I'm giving. In the earlier writ petition, what my learned friend here is referring to, the municipality was unrepresented. Otherwise, I would have objected that Jalpaiguri municipality has no role to play in this, since the land is of the Asian Highway. My report also says clearly, even we have done an inquiry. That's what I have to do. I mean, what else can municipality do when the land falls in the Asian Highway jurisdiction? I don't have
Joint
any.
inquiry was not done.
Well, that the PWD has to initiate. How can I initiate in a Asian Highway land? No, even if it is on both of them, how can I initiate? But I was unrepresented in the writ petition, so I couldn't have made this submission that I have no role to play. But since I'm presented here, I'm making the submission.
Now, who is appearing for the Asian Highways? The state?
As well as the PWD mostly.
So the state.
They are separate.
Where?
Separate council.
Separate councils for Asian Highway?
Sure.
Who appears for Asian Highway? 12, project director, Asian Highway. Project director Anandapara is Asian Highway. Yes, they are served. Who is the council who appears for Asian Highway generally? Usually who appears? Asian Highway? Not aware.
Principal bench probably in few cases. Not
Yes.
principal bench, someone else.
We are unsure who appears, my lord. There is no such, according to as per my knowledge, my lord, there is no such.
No one
concept.
here. But this should be part of the government panel.
No, I am appearing for the municipality here. I do
No,
not.
no, I'm asking the state. It should be part of the state.
Was it so far the present case is concerned on earlier requisition, national highway, their claim was against national highway.
No, not at all.
No, not in this case. In earlier requisition.
Authority has been created as a special purpose vehicle for the purpose of inspection of certain projects, the Asian Highway. So, they are represented with their own set of norms. They does not, the Asian Highway is a stake of central government. Though it is the implementing agency is the PWD.
Please serve once more and come back to this Asian Highways. Because they have to be directed, isn't it? So in their absence, it will be a futile exercise. No. Next circuit.
Let my name be excluded, my lord. The municipality has no role to play.
Remain, let us see who has what role. Now, this letter is by the Assistant Engineer, Jalpaiguri Highway Subdivision.
Yes,
That is the PWD.
Because this road, this portion of the road over which they are alleging illegal process does not belong to PWD. That is, they
Does not belong to PWD.
No. Actually, from Lordship takes up para 4 of their petition because they are not, petition is not certain whether the lands belong to a state highway or Asian highway or national highway. Because earlier petition they have claimed against national highway. In this case, they have not been made for it because they have to ascertain first the land, owner of the land, actually. No, that is true. That is PWD has issued because the portion of land does not belong to them.
They say that it doesn't, serve the Asian Highway once more and come back. If someone has to appear from the principal, then someone has to in that case. Can't help, sir, can't help. It's a 2023 matter. How is it prolonged and prolonged?
No, not prolonged at all, my lord. The earlier occasion substitution was filed.
Filed in June 2020.
It would have been easier if you could have come back with a contempt application. That would have been more effective, isn't it? Huh. Report submitted on behalf of the municipality is taken on record. Paragraph, none appears for the 12th respondent despite service. Paragraph, the petitioner is directed to serve a further notice upon the 12th respondent, intimating the adjourned date. Serve at the principal bench and find out.
My submission is reported that I am saying that municipality is not a necessary party and
যেখানে record taken on record করলাম না তারপর একটা লাইন করুন, learned counsel for the municipality submits that the municipality is not a necessary party to this writ petition. since the allegedly encroached portion does not fall within their supervision or control.
Get for.
তারপরে none appears. Huh? Okay. A paragraph, the matter is placed before the next available settlement. Next.
May I please your lordship? I am for the petition lordship. In the earlier.
Yes. Service complete?
Yes.
Who is appearing?
I'm for statement.
This is regarding this appointment.
Municipality?
No, the state.
Who is
Not-
appearing for the municipality?
I think Ujjal Laksam.
Where is the service on the municipality? State service is there. What about the municipality?
Let me come back to Mother Lordship.
Not tomorrow, next circuit.
Uh,
Since service
just
upon the municipality is not complete,
Wednesday.
next circuit.
Last
Service not
occasion-
complete. I
Last
will not-
occasion Ujjal was there. Municipality lawyer was there.
No, there's an observation that it was not served. Since service upon the municipality is not complete, let the matter appear before the next available circuit.
Get for.
My lord, I'm appealing for the petition.
Yes.
Lord,
Yes,
the
my
affidavit
lord,
of
I am
service.
appearing on behalf of respondent.
Lordship, before Lordship gets into the thick of the brief, the matter in nutshell is this, that the moot
Who
question.
is appearing? You're appearing?
CGST.
CGST. And the state?
My lord, my
And
lord.
State is also,
So, my lord, the dispute in nutshell is this, that whether a party can take advantage of his own wrong or not. What has happened in this matter, an adjudication order was passed. Thereafter, peculiarly enough, that adjudication order was never uploaded in the common portal, that is the server. Neither was the notice of demand, that is the, nowadays it's called the summary of order. That also was never uploaded. Now, unless these orders are uploaded in the server, the link to prefer an appeal
Is
does
not
not get
activated.
an enliven. So various times it has been brought to the notice of the authorities concerned. Petitioner ran from pillar to post, but to no avail, my lord. It was finally only a copy of the manual, copy of the adjudication order was handed over, but not the notice of demand. Be that as it may, my lord, the petitioner waited. As your lordship knows, under section 107(1), it is 3 + 1, 4 months with the grace. So on the last day, on the very last day, that is 30th of June, petitioner filed a manual appeal. There are notifications and there are promulgations from time to time, sometimes encouraging people to file manually, sometimes taking away that right. Now, at that point of time, 30th June 2023, this was filed. Now, Lordship will kindly come to the adjudication order. How it was filed, I'll show you, Lordship. This is at page 27. Page 27 is the start of the adjudication order. I'm not going into the merits. Passed on 8/2/2022, issued on 8/2/2022. And then to the last page of this order, it's signed again on, of course, 8/2/2022, that is at page 33.
Yes.
Then on the next page, 34, for the sake of brevity, I have annexed this in the next page itself. Otherwise, it should have been annexed if chronologically way later. This is the GST DRC 07, which is the summary of the order or the demand notice, basically. Lordship sees the date, 21/4/2023. So after 1 year, they had issued me this notice of demand, that too manually.
So having no other alternative, my lord, kindly comes to page 36. I filed this appeal, which was filed on the stamp at the bottom will show 36/2022. That was the last date available. And then again, a pre-deposit of 10% has to be.
So you filed the appeal before you received the summary of the order?
True, my lord. Without the notice of demand, I had to file the appeal. I had the adjudication order, the copy of the adjudication order. Basing on that, I had filed. And then, my lord, at page 38, lordship will see the pre-deposit of 12,750 was also paid. Now, admittedly, the position of law is this: until and unless I I tendered the pre-deposit, my appeal is not tendered legally. Only when the pre-deposit is tendered, my appeal is tendered. Now, it's very important to know the practicality of the thing, how this pre-deposit is tendered. It is not by way of putting a challan or making a bank transfer. It is not by that way. While we prefer an appeal online, then there is another link which guides us to the pre-deposit, which again lets us debit our cash ledger, electronic cash ledger. Now, since it was not filed manually, I could not have that link to get the electronic cash ledger debited. So what I did, being a diligent and tax-paying citizen, my lord, I had paid the money in the electronic cash ledger in my bank, wrote a letter to the authorities on that very day, kindly debit my electronic cash ledger to that extent. I did whatever was within my power. Lordship will kindly come to that letter. That letter is at page 49. My lord shall kindly come to page 49 straight away. 49. This is the letter which I'm going to place before your lordship in its entirety. Yes. This is dated 36/2022 at the top, and at the bottom the receipt is also marked as 36/2022. It was receipted on that day. Respected madam, this is to inform you that an appeal against aforesaid order in GST is required to be filed online as per provisions of law. Since the said order as well as DRC 07 is not available in the portal, the appellant is a registered dealer is unable to file appeal online. As the system is popping up message error, copy of the screenshot annexed herewith. Again, as per law, 10% of the disputed tax that is amounting to such and such is required to be deposited online. As the payment of cash reflecting the same in cash ledger, the same cannot be debited or set off towards the payment of pre-deposit against appeal. As per GST rule, today is the last date of filing the appeal. In view of the above, we are filing the appeal, GST Appeal 01 offline, and request to accept the appeal. Further requested to debit the pre-deposit amount from my cash ledger. Copy of cash ledger enclosed. Why was it enclosed? My lord, I asked this question to myself. To show I had enough fund. And lordship kindly turns the page. This is that error report lordship can see. This is that error report at page 50. Yes. And then, my lord, the next page, lordship will see electronic cash ledger, the screenshot, serial number 2, although it's very small lettered, my lord. This is 3/6/2022. Yes, yes. And there by cash, I had deposited, there is some amount of money. And then again, lordship on the next page will see the central cash ledger where same credit has been done to the tune of rupees 12,750, and lordship kindly turns to the next page. The total balance is more than 97,000. So it could have been deducted. Now what happened, beloved? I have also filed a condonation of delay just to be by way of abundant caution, so that there's no question on that 1 month grace period as well. Now, my lord, what happens? The impugned order is served upon me saying that your debit had taken place on 21st of July, which is 21 days late than what you should have filed. So therefore, we are not going to entertain your appeal. My lord, before going into that impugned order, only one small. Lordship will kindly take this. This is Supreme Court Act 2007, 11 SCC 447, Kusheshwar Prasad Singh. Lordship kindly takes para 16. or should I start with paragraph 15 from the middle of paragraph 15, or I should put paragraph 15, my lord. In Union of India versus Major General Madan Lal Yadav, the accused army personnel himself was responsible for delay as he escaped from detention. Then he raised an objection against initiation of proceedings on the ground that such proceeding ought to have been initiated within 6 months under the Army Act. Referring to the above maxim, this court held that the accused could not take undue advantage of his own wrong, considering the relevant provisions. The last line, this court at SCC such and such referred to Broome legal maxims, wherein it was stated, it is a maxim of law recognized and established that no man shall take advantage of his own wrong. And this maxim, which is based on elementary principles, is fully recognized in courts of law and equity, and indeed admits of illustration from every branch of legal procedure. It is settled principle of law that a man cannot be permitted to take undue and unfair advantage of his own wrong to gain favorable interpretation of law. It is a sound principle that he who prevents a thing from being done shall not avail himself of the non-performance he has occasioned. To put it differently, a wrongdoer ought not to be permitted to make a profit out of his own wrong. In view of the findings recorded by us here in above, we would have allowed whatever. So that was the thing. And another small thing, my lord. Since here the state is concerned, it's not exactly a person. This question may arise that whether the same thing can be stated regarding the state or not. My lord, para 17, page 8, internal page 8 of the judgment. At the very first paragraph, 4th line from the top. However, the fact remains, Lordship has got it.
Yes.
4th line from the top. My lord. However, the fact remains that the superintending engineer unreasonably delayed the decision, and in spite of persuasion and protests by the contractor, did not promptly take and communicate his decision on these disputes. The state government ultimately yielded to the demand of the contractor by appointing an arbitrator. Once the arbitrator commenced the arbitration proceedings, the state of MP gave a second thought and receded its step by choosing to raise an objection to the maintainability of the arbitration. This was the facts. Now, Lordship kindly comes to the paragraph 17 at the last, that's the last paragraph. No one can be permitted to take advantage of one's own wrong. The respondent state of MP cannot and could not have been hard to plead denial of the two appellants' right to seek reference to arbitration for non-compliance with the earlier part of the clause such and such. In case of Messrs. HON'BLE Das and Sons, the clause was complied with. Alternatively, even if it was not complied with in such and such case, but certainly in the case of Messrs. M.K. Shah in this matter, my lord, the fault for non-compliance lies with the respondent state of MP. Through its officials, the plea of bar, if any, created by the earlier part of clause this, cannot be permitted to be set up by a party which itself has been responsible for frustrating the operation thereof. It will be travesty of justice if the appellants, for the fault of respondents, are denied right to have recourse to the remedy of arbitration. A closer scrutiny of the clause clearly suggests that the parties intended to enter into an arbitration agreement for deciding all questions and disputes arising between them through the arbitrator, and thereby excluding the jurisdiction of ordinary civil courts. Such reference to arbitration is required to be preceded by a decision of the superintending engineer, and a challenge to such decision within 28 days by the party feeling aggrieved therewith. The steps proceeding coming into operation of the arbitration clause, though essential, are capable of being waived. And if one party has its own conduct or the conduct of its officials disabled, such proceeding steps being taken, it will be deemed to be the procedural prerequisites were waived. The party at fault cannot be permitted to set up the bar of non-performance of prerequisite obligation so as to exclude the applicability and operation of the arbitration clause. My lord, that is my humble submission here. The doctrine of estoppel completely bars the respondents to take the plea of limitation. My lord, I'm not praying for condonation of delay. I am praying that they should be stopped from taking this plea of limitation in this case, because it is they for whom, for the vice of whom today I am in a predicamented situation. And this is, my lord, M.K. Shah Engineers versus State of Madhya Pradesh, reported in This is Appeal Civil Case 5961 of 1983. এটা reporting টা লেখনি। 1991 first volume SCR 419.
1991, first volume.
1999
9, yes.
first volume SCR within bracket 1 SCR 419. my lord.
419.
419. This is a bench of Lordship celebrated Justice Sujata Manohar and R.C. Lahoti. So I pit my case on these two matters, my lord, and Lordship now kindly comes to the impugned order. Just to correlate what has happened, 58, Lordship will kindly take page 58. The order starts at page 54, but 58, from 58, the observations and the inferences start.
Yes.
My lord, grateful. 5.2, I find that the demand in respect of such and such amount under provision of this, read with this, regarding wrongful availment of utilization of Tran 1 has been, my lord, this is the first, and second, 5.3, Lordship will kindly come. I find that the appellant bearing GSTIN number this filed the instant appeal on 36/2022, whereas the impugned order had been issued by the Superintendent CGST CX Raiganj Range on 8/2/2022, which was received by the appellant on 18/2/2022, as per GST appeal dated 36/2022. Further, DRC 03 payment of the prerequisite deposit was made by the appellant on 21/7/2022, which should be treated as the effective date of filing of appeal under clause B. My lord, pausing here for a moment, this debit was also not done by them. I was instructed to once again pay it by way of voluntary payment challenge, that is GST DRC 03. I did it once again. But what they do now, they quote section 107(6), subsection 6, Lordship kindly sees, no appeal shall be filed under subsection 1 unless the appellant has paid in full such part of amount of tax, interest, fine, penalty arising out of the impugned order as admitted, and this is the clause, a sum equal to 10% of the remaining amount of tax in dispute arising of the said order, subject to a maximum of this, in relation to which the appeal has been filed. In the instant case, it is observed that the appellant has failed to adhere to the relevant provisions of law, filed the appeal after 152 days of issuance of the impugned order, considering the fact that the pre-deposit under clause B of subsection 6 of section 107 was paid on 21/7/2022, and the receipt of the impugned order was on 18/2/2022. Further, it is also pertinent to note that the time within which appeal to be filed is provided under such and such 107(1) and 4. Lordship, I won't trouble your Lordship with that. Kindly, Lordship, turns to the next page. The order, I reject the appeal filed by Messrs Millennium Cement Company, that's your petitioner, my lord, without going into the merit, as the appeal in hand has been filed beyond the stipulated time frame provided under such and such provisions. Lord, that's my humble submission before this honorable court.
Yes.
My lord, admittedly, the impugned order of adjudication was issued on 8/2/2022. 8/2/2022. And the said order
18/2/2020.
Sorry, 18/2/2022, and the same was subsequently received.
No, it is 8/2/2022.
It was issued on 8/2 and it was handed over to me on 18/2. I have declared it in GST appeal.
You have sent it to post by post on 18/2/22. I have a track report.
Nobody is denying that. I got the manual order. Otherwise, I wouldn't have been able to file the appeal. GST DRC 03.
You have not received the order in original. That was your contention, that you have not received the order in original.
On the portal.
My lord, the order.
Was it uploaded
Yes, it was uploaded subsequently.
in the portal?
But in the portal, but due to some technical features not on the very day, but subsequently it was uploaded. That is the fact.
Which
So
day?
And from the postal track report, my lord will find that the order in original has delivered to the assessee on 8/2.
18/2.
18/2. Order of 8/2 was delivered on
18/2, yes.
Moreover, the requisite fee for preparing appeal has not been filed.
So the appeal was this thing. These are two objections.
What was was there an opportunity for the petitioner to put in the requisite fees
Yes.
of 10%?
Mentioned in the order. Mentioned in the.
Yes, but
appeal.
is it a fact that unless the order is uploaded, the avenue for filing an appeal and depositing the amount is not open? That is a fact?
That is the fact, but the petitioner can file the appeal, can appear before the adjudicating authority and can file the appeal manual. Can That is file what the I've done. appeal manual. That is what exactly I've done.
But the same was filed long after a period of 120 days.
My life.
It was filed.
GST DRC 07 was served after 1 year.
These facts are.
Page 34. Page 34, Lordship kindly
Let him
says.
complete, let him complete.
These facts are required to be into your notice. So give their opportunity so that I can file everything you want.
My lord, this.
By opposition, file a report. File a report in the form of an affidavit. Don't go to affidavit in opposition.
We can file a.
Come back with a report.
My lord, it is.
Opposition will take away.
My lord,
The track report and the other documents.
Please.
it
come
is
back
not
with-
track report. My lord, then let me submit one small
He
thing.
wants to come back with a
I'm
report, let
only.
him do that.
Track report.
He wants to come back with a report.
Very well.
Let him
My
do
lord,
that.
I have no objection. Only one thing, Lordship kindly makes him submit in that report is that exactly when the order was uploaded in the portal.
No, he'll come back with all the details.
Because, my lord, he is harping on the fact that it was served upon me on 18/2/2022. I in my petition have written that this is no new ground. I myself, page 34, Lordship kindly considers for
Let him
once.
come back. I will consider the entire thing. I mean, maybe someday. You can
Because-
take these judgments back for the time being.
My lord.
Come back with your report.
Within
The order passed by the appellate authority on 22nd March 2023 is under challenge in the writ petition. Paragraph, learned counsel for the respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, the matter be placed before the next available circuit bench.
My lord,
You can take your track report back.
my lord, I may be
Please
protected for
include
the
this in
time.
your affidavit.
My lord, I may be protected for the
Show the
time being. my
affidavit
lord.
of service. Yes,
I may be protected for the time being.
what is the coercive action that you're
My
expecting?
lord, attachment of my bank account. That is because under GST Act, my lord, there can be 3 attachments. Even
Bank account.
no, they do not give.
A notice is required to be.
No. Under section 83, you don't need any notice. No. It is a provisional attachment, and you need not give me any notice.
Let
Lordship will
there be
kind.
no coercive action pursuant to this
Yes.
order.
Yes.
Yes. Worship, acting and acting. No coercive action be taken against the petitioner pursuant to the order impugned
My lord.
dated
My lord, the impugned order is dated 22/3/2023.
22nd March 2023 in the meantime.
Till this.
In the meantime,
Till
till it appears.
till the disposal. My lord, till the disposal, because
Till the filing of the report.
no.
Filing of.
In the meantime, yes, I've stated that.
And my lord, the matter to appear on
Next circuit.
next circuit.
I'm for the petitioner.
This is my lord, interest of gratuity and arrear pension, my lord. Single PPO died in hand.
Sufficient interest of gratuity has been taken today, again tomorrow.
Not only this one, my lord.
112 matters running, so writ petitions. Not today. I've taken up 112 matters, so remaining matters tomorrow. Orders have to be passed in all these
Lord,
matters.
may I get the judgments back?
Yes, I've given it back. So judgment will fill up the bill. No, I'll call it. Yes, remaining matters tomorrow, please. 112 matters have been taken up today. I need to pass orders.
Grateful, my lord.